tired of your crap.
We made contact.
All right, thank you. Was that so hard to do?
No, it's not hard to do, but there's also
the
extenuating circumstances that we
Sir?
tried our best to stay apart.
Sir, no, you made it. I made an order.
We made contact.
Thank you. That wasn't that difficult.
Appreciate it.
All right. Despite this violation and under the change in circumstances, the court is going to continue you on community control at this point in time. For this violation, the court's going to order you to serve 30 days in the Warren County Jail. You get credit for the 10 days you've already served in this violation. You have a total of 53 days total. So you're going to serve an additional 20 days for violating my order, but I'm not sending you to prison today. Mr. Long, the no contact order is dismissed. Again, if you don't get some help with regard to your anger issues, whatever your violent tendencies are towards people that you profess to love, then you're going to be back in front of me. And I'm going to tell you right now, if you come back in front of me on an F3 domestic violence, we won't be, it's not going to matter what attorney you hire because you're going to be going to prison. You understand me?
Yes, sir.
All right, that's all.
Your Honor, would the court consider EMHA and
No,
the jail?
he violated my order, Mr. Brum, and he's going to pay a sanction for violating my order. Moving forward, the no contact order is dropped, but he knowingly violated my order. He's not going to prison today, but he's going to be sanctioned for violating my order. That's all.
Thank you.
Ms. Sumter, you want to step up to the podium?
Case number 25CR42558, the State of Ohio versus Chelsea Sumter. Ms. Sumter previously was here for a preliminary probation violation hearing and waived her right to counsel and admitted to the violation. I understand you're continuing to violate my orders as well. I don't understand. This is not that difficult. You have a substance use disorder. You continue to use a substance that I forbid you to use. This isn't complicated.
I understand.
Well, at this time, you're going into custody. Deputy, take her into custody. You will be screened on Monday for Judge Peeler's recovery court. But until you are screened, if you'll talk to Jennifer, have this put back in my docket for Monday afternoon, but she's going to spend the weekend in jail. If you continue to use Ms. Sumter, I'm going to tell you right now that the sanctions will continue to increase. So this time's going to be let's see, today's Friday, 1, 2, 3 days in jail. And that next time is going to be 10, and we're just going to keep increasing it until you get the message that you're going to follow my orders or you're not. Okay, that's it.
No. Oh, sorry.
Eviction. Wife. Disrespectful. I thought maybe there it is.
All right, we're about to begin our small claims talk. We've got defendant we're having trouble connecting with. Sir, you've logged in as Samsung SM. What's your name? Miss Rhoda, is that Leighton Rhoda?
Yeah, I believe it is.
He's not very good at this. He's logged in. I can't hear him and he won't answer me.
Probably can't hear you either.
Wandering around and he's making me dizzy, and I wave at him and
Can we hold up the sign and tell them?
I have one that says you're on mute, but he's got the sun right behind him. He looks like a shadow in an interview where they try to block the interviewer's face. He was walking all around inside the house, but he could buy a ticket on the Clue bus and get on it. So right now we're not even connected. Plus he's got an annoying view of a sun shining in my eyes with his head. So are you Leighton Rhoda?
I put the sign. No. Look you up. Does it say? Okay.
You could buy these at Target. Somebody sent me this. I had somebody that actually made some also. We have a sign, but he's not real with it. So let's see what else we got. Kristen Brandeis is here. And Tabitha Schaefer is here. Carly Friesen is here. And Mr. Carr Sealing is here. Let's start with that one. Ms. Friesen, can you hear me?
Yes, Your Honor.
Do you prefer Friesen or Schwartz?
Either one is fine.
All right. This is file 252397SC. It's entitled Kristen Colette Brandeis versus Carly Danielle Friesen. I previously entered a judgment in this matter after a trial on behalf of plaintiff Miss Brandeis, the amount of $2,297.76. The defendant was going to have a payment plan where she paid $100 a month starting last January. Ms. Brandeis, did you receive any payments?
I received January, and that's why we're here, because she wrote it to the wrong name. I then have received February and March, both late, but I have received those.
What was wrong with the January check?
She spelled my first and last name wrong, and so the bank will not cash or deposit the check.
All right. Well, Ms. Friesen, it does sound like you did try to make the payments. The January payment has come back to your account.
Your Honor, can I speak for a moment?
Yes. First thing, what I'm going to do is I'm going to put you both under oath. You both please raise your right hand. You both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
I do.
All right. What did you want to tell me?
So when we were at court for the first time, what I received, the information that I received from you, the knowledge and the information that I remembered hearing and I have on paper is that I was to make a payment to Brandy's on the 15th of every month.
Correct.
Now, that was to make that payment on the 15th. If I am mailing that, of course, she's not going to get it on the 15th. This lady has been extremely difficult. I have paid her in January. I made a genuine mistake. I genuinely misspelled her name. I did not mean to do that. That was a genuine accident. Moving forward, April and March have been paid and they've been spelled right.
February and March have been paid.
Yes. Excuse me, February and March have been paid and the name is right in those and the amount is right. So if we just take a little look at this and understand that, okay, that was a genuine mistake. And I have messages here in this pamphlet that she wrote, book, and she even called my bank. I made that genuine mistake. That was on me. Absolutely. I did not mean to do that though. She goes, so she texts me. She's kind of rude about it. I mean, you can see it in these messages, and she's not very whatever. And I think that I also feel in my heart that this is more against my character than anything. She doesn't like me, and that's very well known, and she doesn't have to like me. But I am making an effort. I am making these payments.
All right, stop. You did make a payment. It was in the wrong name. You made the next two payments. If they were deposited by the 15th, you're to make the April 15th payment.
Mm-hmm. I know that, and that's coming up, and I'm prepared and ready for that. I do not think that my wages need to be garnished. I don't want them garnished. I'm doing just fine.
Stop. I'm not going to allow your wages to be garnished. I want you to make the next payment. You won't get credit for January because it didn't clear, but you made the next two. I'm surprised the clerk even set this for a hearing.
Yeah.
So if she doesn't make the April payment, we can have further hearing. But she's Kristen, Krsten, Brandy, Brandy. Anyway, you'll spell it correctly. Kristen, Brandys. So you to make the next payment on April 15th and then May 15th.
Yep, and that's what I've been doing.
Judge,
all right.
Can I say something real quick? My issue isn't the payments moving forward. She has made those payments. It's the fact that the simple solution was when I did contact her bank. Prior to working where I work now, I did work for a bank, so I understand very clearly how cashier's checks work. The solution is for her to take the check that whether it was a mistake or not, people make mistakes. That's not why we're here. It's to take accountability. So the solution is to take the check, go to her bank, redeposit into her account, and then have the cash or the bank issue the check correct. That was my solution. That was what I was asking. She refuses to take accountability, and that is why
Well, my solution is she's going to make the April payment and she won't get credit for January.
Okay.
And she'll make the May.
Can she make a double payment and that will clarify January and April?
No.
It will pay February, March, and April.
Because I still have this cashier's check sitting here, which was taken out of her account. So she is still out of $100. So if she picked it up and readmitted it, then she's not out any money. What do I do? This is her $100.
All right.
Miss Brandy.
Stop. So you have that check, but you can't deposit it.
Correct. And her bank will not cash it because it is not spelled correctly. And if they were to, they said they're not even a guarantee that they would, but if they were, they would take a fee of it because I do not do banking with them. And the intended purpose of the cashier's check is to deposit.
All right. So even if you just ripped it up, she's out $100, but you can't receive it.
Correct. Okay. So you would think on her end to clarify the situation to put her money where it should be rather than going nowhere, she would take the initiative step to take the check, return it to her bank, and make right on her wrong. But
All right,
this
I
is
don't
why
want
the
you guys to
character
have
is the
contact.
issue.
Miss Brandeis, I want you to forward the check to the court.
Okay.
Can I speak, Your Honor? I have one more thing that I'd like to state, or not state, but say.
Just a minute. All right, Miss Brandeis, you send me the check. I'll confirm that the court received it, and I'll send it to Miss Friesen.
Okay. Thank
And then
you.
we'll send it back to her. She can do with it what she chooses to do. But we'll start with your first payment being made in February, your next payment being made in March. All right, Miss Friesen, what did you want to tell me?
I'm not trying to be difficult. I just want to say that she does reach out to me. She'll text me. And I want to also make clear that I'm not trying to not take accountability for my actions. That needs to be known to her. I have clearly tried to respond in these text messages.
All right, well, let me stop you. Miss Brandeis, leave her alone. If you're a collection agency, you can't send her monthly stuff saying, hey, please pay the bill.
That was
So
more in the
she
direction of
screwed
the
up
court for
January and you're
documentation.
trying to unscramble it, which I appreciate. You don't need to have any contact with her. I've issued a judgment. She's going to make the payment each month. If she doesn't make the payment, contact the court.
Right.
You send me the check, we'll send it to her, and then it's her $100. She can figure out what to do with it from there, but she doesn't get credit toward this payment. So Ms. Friesen, she's going to send me the check and I'm going to send it to you. Are you still at apartment D?
Yes, Your Honor.
All right. Go ahead and make the April payment and then the May payment. She'll send me the check. I'll send it to you. And I've asked her not to contact you. If she has issues, she can contact the court.
Okay.
All right. Hopefully,
Can I
$100
just,
a month is going to take 2 years or more to get this paid off, but it does chip away at the debt.
yeah.
All
And
right, you're both free to go. Thank you.
Your
Thank
Honor,
you.
can I say one more thing?
All right, I'll remove Ms. Brandeis, and I'll remove Ms. Friesen. All right, we're still trying to connect to Leighton Rhoda, who's doing I don't know what. Do you have a telephone number for him?
Yes.
All right, we're back. We've got a couple more matters to take care of. Appreciate everybody's patience. Mr. Jones, would you come up to the podium? We'll take care of your matter, and then we'll have time to take as much time as we need in the next case. This is file 26213OT. You're Robert Earl Jones.
Yes, sir.
Mr. Jones, you got charged with no valid operator's license under Sturgis ordinance. That's a misdemeanor, punishable by up to 90 days in jail and a fine of up to $100. Carries 2 points. The matter was adjourned. Thanks. Yes, thank you. The matter was adjourned to see if you could get some headway with your license. You weren't able to do that. So you had a pretrial with Mr. Timothy Reed, the River City attorney today. This is People versus Robert Jones, 26213OT. He indicated you're simply going to plead to the charge of no valid operator's license, and I'm going to give you a fine and costs because he does not object to fine and costs only. Is that your understanding?
Yes, sir.
Anybody threaten you to get you to plead to this
No, sir.
or promise you anything?
No, sir.
All right. And Mr. Wright, some of these rights also apply to you. Do you understand that if you enter a plea here of guilty, you'll be giving up your right to have a trial in front of a judge or jury? There will not be a trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. You don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury cannot hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Rules are a little different for Mr. Wright, and we'll explain that. All right. Were you driving a car in Sturgis on February 3rd?
Yes, sir.
You do not have a valid license?
No, sir.
Where were you going?
I was taking my son to Walmart to get him a phone.
How old is he?
15.
Yeah, 15-year-olds got a phone now. And he indicated you were going to try to get squared away, but you weren't able to.
Yeah, I got to have my birth certificate. It's in Chicago, so.
How'd you get here today?
Courtney.
All right, very good. Where are you guys living now?
We had to split up so I'm living in a hotel in Sturgis and she lives in White Pigeon.
Well, I think probably it was okay to get out of that place you were at.
Yeah.
Your son has an open warrant for him.
Who?
Robert Earl Jones II. Is that your son?
No. My son's name is Solo.
Oh, well, Robert Earl Jones II has an open warrant. He's 21 years old.
I have no son named Robert.
All right. You haven't paid the fine on the last one.
I thought I had that paid because I had it taken out of my wage garnishment.
All right, well, we'll figure it out. All right. $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. $200 due as part of a payment plan. That other case is, oops. (24465ST). We'll figure that out. Laura, would you come get this file for me, please? All right, Mr. Jones, you go out to the counter. We'll find out about that other ticket and put this on a payment plan.
All right.
And stop driving and say hey to Courtney.
Okay. Well,
You're good to go. Go out to the court office. Everything is in such disarray. I'm not sure. Here, she can hear me. They're moving boxes and college hunk dudes are here moving stuff around, and it's very chaotic. Thank you for your patience. You're Robert Norwood Wright. Christopher, yes. Not, that was Robert Jones. Christopher Wright, correct. Thank you. I saw you the other day on the video feed.
Oh, you tried to, but the video.
Yeah, I couldn't see you. I could hear you, but you were there. We set this matter for this morning. The original attorney was Mr. Bush, worked out a plea agreement in this case, and you were placed on probation. Also present is your probation officer, Daniel Frazine. What is set for today is a hearing on your probation violation. The allegation is that you were placed on probation on October 20th of 2025 for 24 months. You failed to report on a monthly basis, failed to abstain from alcohol, failed to pay fine and costs, and failed to participate in treatment program as directed. Daniel filed this probation violation, and the matter was set for an arraignment and hearing this morning. And I had the jail arraignment, as I said the other day. We met, Mr. Bush and Mr. Frazine met for quite some time this morning while we're doing other things, and we met in chambers. You got some things you'd like me to know about this, but Mr. Bush says that you would be willing to admit certain components of this violation. Is that correct, Mr. Bush?
Yes, Your Honor.
What's Mr. Wright willing to acknowledge?
He would admit that he has not paid, that he has missed reporting, and he has not tested regularly.
All right. Now, I went through those rights. Yours are a little different. You have a right to have a hearing, and we're ready to do one today, where it has to be proved beyond a preponderance of evidence that you violated the terms of your probation. You also could admit that you failed to report, failed to test, and failed to pay fines and costs. And if you're willing to admit to that, then we'll go on and figure out what to do as a sentence for this charge. Do you understand?
Yes, sir.
Anybody threaten you to get you to admit to this violation?
No, sir.
Or promise you anything?
No, sir.
And you were placed on probation. We talked about several different treatment plans, the culinary school, some other inpatient things. None of those happened. So did you fail to report to Mr. Frazine on a monthly basis?
Yeah, I went to Bear River for a month, and then got out, had some issues getting reference letters to obtain that school that we talked about. And I was having trouble staying away from my mother's so that I could take care of my kids. My wife really needed me, and it just, I got caught up in a lie with my probation officer, and it just went downhill from there.
All right. And so then you weren't paying any fines and you weren't testing during that time?
Correct.
All right. I'll accept his admission. All right. John, let's hear from you. And then Mr. Wright wants to tell me some things. Then we'll hear from Mr. Frazine. Anything you'd like me to know, Mr. Bush?
No, he still has some retail fraud matters to take care of in this court, but he has been in jail for, I think, 9 or 10 days.
14.
I talked to him yesterday. First thing he did was apologize to me about what was said in court a few days ago. And I noticed today that he also apologized to Dan, his probation officer, since we've been in the courtroom this morning. I'm not a psychologist or substance abuse expert, but I think certainly sobriety and the time in jail has cleared his head, and he's probably in a position to make good decisions. Thank you.
Mr. Wright, we tried to accomplish some things here. Daniel spent a lot of time on this case. Once upon a time, we were all here in the same building, and Daniel would come up and see me and tell me what was going on. And we were very encouraged about the culinary program, which would have provided housing for you and your family, and you needed letters of recommendation, which I'm not sure is accurate, but we gave you one the instant we knew that you needed one. Anyway, those things didn't work out. So what would you like me to know?
Well, the culinary school needed three letters. Pivotal was supposed to write one. That fell through. Dan, yes, wrote a very nice one that I appreciate. And then I was waiting on one from a clergy member, and that one fell through. I don't have many other resources other than that to obtain the reference letters, and I was getting frustrated. And at the same time, I was being told by my mom and my wife that I needed to be around to help her with the kids, but at the same time, I couldn't be there because of probation, and the courts didn't seem to want to lift up that stipulation. And so I thought that the kids came first, so I decided to help them out rather than comply with my probation, which was a bad decision. Dan was there for me. He did nothing but good for me. I'm the one that fell through on a lot of promises that I should have kept. I'm starting to get a handle on my sobriety. Bear River was definitely a good choice. I wish it was longer. And I think the system fell through on me a little bit, but I felt I did it all on my own. I'm a new father of three little ones that scares me every day of not being able to provide or be there for them and whatnot, and then still at the same time tackle my sobriety. My mom's disabled and is taking care of my kids along with my wife, and that's not fair. I've been trying to find programs to where I could tackle my sobriety and still be a father at the same time. I haven't been able to find that program.
Paul, could you check the system and see how much credit Mr. Wright has?
They told me it was 10 days.
He says 14. I guess we'll find out.
I called the bookings, but just before coming to court.
Booking told you 10?
Yeah.
All right. Go ahead.
I am very aware of my issues and what I've been causing, the disruption in my family and in the courts. Sobriety is definitely a long road to handle. There's a lot of things that I've acknowledged within myself, my chemical imbalance. I was off my medication. I had problems getting back on my medication once I left Bear River. And I know now that I need to stay on top of that medication. It helped quite a bit in order for me to make right decisions. I'm just trying to, I'm 40 years old, and yes, I need to take my head out of my rear and start acting like an adult. Stop putting blame on everything else.
That's exactly the right thing. And you say it, but then you contradict it. You're right. You need to just own it and stop blaming everybody else. And those are good things to say. You mentioned some retail frauds. I don't see anything in our system. Is it another jurisdiction?
No, they have the sheets on it and they've authorized it. It's 4 separate offenses, which they're going to, they've already authorized and pulled them into 2 retail fraud seconds charges.
Where from?
Walmart, I believe, here, but our prosecutor has authorized them or is in the process of finalizing the authorization.
Well, they haven't made it to our system yet.
No.
Okay.
See, I don't believe he's been arraigned on those.
No, they haven't even
I brought him up and I shouldn't have. but
Yeah,
this
they
guy
have
The
knows
blue
what to do.
sheet last week.
They haven't filed the paperwork yet, but sure, they're in the background. What do we have for jail credit? Yeah, that's what Daniel had. Well, we did it. I called you at your sentence, Tasmanian devil. I didn't mean it as a necessarily insult, but you're a spinning tornado of chaos visited on the people that you love the most, your mother, your wife, your kids. I also think there's a methamphetamine component in here. I think when you got out of Bear River, I think you got in with the wrong people. I think talk about chemical imbalance, throw methamphetamine into that mix, and you're a recipe for disaster. I think in your heart, you want to do the right thing. You want to be a good dad. You want to be a good husband. You want to be a good son. But I think your family's afraid of you. I think the Tasmanian devil sower of chaos scares the people around you. Don't know anything about these retail frauds because the prosecutor hasn't actually filed them yet. So they're coming. But I'd try to deal with them right now if I could. This was an unusual sentence. I ordered 93 days and deferred all 93 days. And the wheels have fallen off. I'm going to get off your back. Probation is revoked. No, waive all the fines and costs. 93 days, credit 10, leaving 83 days to serve. You'll get good time credit. 93 days is about 77 days minus 15. We'll find out about these new charges when they come. Pivotal and Lauren are at the jail. Maybe they can work on the next placement. But this didn't work. Daniel said it. You need some forced clean time. Maybe John said it. Get squared away. I'd like to see you get your goals of being a supportive father, but you're not there right now. So you can go with the court officer. You're off probation. When the prosecutor files these new 4 retail fraud charges, I guess we'll deal with those as they come. I don't know anything about them, but this matter's done. You're good to go, Mr. Wright. Maybe you'll be some sort of a trustee. All right, thank you, John. All right, that completes our record for this morning. As I indicated, we have some PPO hearings. And the more we looked at Ms. Inez Lopez, the more we realized how screwed up it is. So TJ got a lawyer for her. I think she got a ticket for driving. She wasn't even the driver. They didn't get her name right. It's just a big mess. So I think it's probably going to end up getting dismissed. All right. So we'll stop the live feed. I'll go do some more moving. And we'll be back.
185-6611, counts 1 and counts 2, SD 185-68871. State your name for the record, Mr. Lucci. You have to press *6 to unmute yourself. Where'd he go? Fidel Lucci, press *6 to unmute yourself, please. He's the one that was telling somebody else to press star six.
He knows because I told him he's in the hall.
Go tell him to press star six when you get him out of here.
Yes, I'm Fidel Lucci.
All right, good morning to you, sir. Day is date and time set for a trial. At this time, Officer Essing, I don't have an Officer Essing that is checked in on my docket. And we're going to dismiss your cases on the court's own motion.
Case People versus Kent Robinson.
Bring on bring for the people.
I don't think we have a PD. So
Mr. Brown is here. And he's assistant.
He might be in the back talking with one of his interests.
This. You not.
Court calls case People versus Sharon Abbott.
Bring on bring cook for the people.
Sherilyn Foster Tucker on behalf of Sharon Abbott.
Your name?
Sharon Abbott.
Excuse me one moment. What are you doing?
Wrapping up my cord, Your Honor.
Oh, okay. All right. I just saw you pulling wires out of the table. I was worried. All right. I have before me a plea form. Form indicates that defendant is going to plead no contest to as charged to the count of indecent exposure. On a successful plea to that charge, then there's an agreement, a sentence agreement to a prosecutor's deferred. That's the court's ruling.
That's correct, Your Honor.
That is correct, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear in affirmative testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Okay.
Do you state your name?
Sharon Abbott.
Okay. I just didn't hear it. Ma'am, it is this court's understanding that you're going to plead no contest to charge of indecent exposure. That's a misdemeanor, punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
I do.
Do you understand what a no contest plea is?
I do.
All right. Two things about it. I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge.
Correct.
Understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Lack of recollection.
And ma'am, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
Signed an advice of rights form. Is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes.
All right. And also because, well, I won't ask you that. Court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-14872. Any objections to the court having reviewed that report?
None from the people.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt to this offense. Ma'am, I do have to apprise you, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. Do you understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea. Oops. In this case, defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2026, 12 noon. And we'll continue. All right. Thank you.
Thank you, Your Honor.
What? Court calls case, People versus Kent Robbins.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Robinson. The Office of the Public Defender does not believe a conflict exists between this honorable court and the Office of the Public Defender. But if one were to arise, we would waive any claims that a conflict exists.
Your Honor, the people similarly do not believe that any such conflict exists, and people make a waiver of any potential conflicts in the avoidance of all doubt.
Right. The court, for its part, also does not believe there's conflict either under the Michigan court rules or the cases decided thereunder, to the extent a conflict does exist, given the witness or will consent to. Your name, sir?
Robinson.
All right. I have before me a plea form that indicates that he's going to be pleading guilty as charged to the domestic violence. Is that correct?
Yes, sir.
Yes, Your Honor. Continue.
May I have it?
Is there, and you solemnly swear the first testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name, please.
Ken Robinson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that? Still wish to plead guilty?
Yes.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form previously?
Yeah.
Is that correct? Any question regarding any of those rights?
No.
Look at paragraph 5. You see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
Probation. Were you on probation at the time of this offense? Yes?
Yes.
Okay. I do have to advise you then that your entry of a plea in this case could be a violation of that probation. If it is considered a violation of that probation, you could be sentenced to the maximum allowable under that other charge by that other court. You understand that? And understanding that, you still wish to plead guilty to this charge?
Yes.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're indeed guilty of this offense?
Yes.
On the date of January 14, 2026, at the location of, what is that location? 3000 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What did you do regarding a Sharonda Stewart Moss that makes you think that you're guilty?
I hit her.
You hit her?
Yes.
All right. You did that on purpose?
Yes.
All right. You didn't have her permission to do that, did you?
Yeah.
You didn't have her permission to do that?
No.
All right. And who was she to you?
Girlfriend. Girlfriend.
Girlfriend? All right. Sir, if I accept your plea, I do have to advise you to commit misconduct between the time of my acceptance of your plea and the time of sentencing. That you would not commit misconduct as defined under Michigan court rules. You would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
April 20th.
April 20th, 2026, 1 p.m.
Yes.
1 p.m. On its conditions will.
Your Honor.
Yes.
Would you consider allowing him to use the phone at the jail, making outgoing calls?
Any response from the people? I've revoked it previously, and
Looking at Mrs. Enda's notes, it looks like there were numerous phone calls that led to his phone privileges being revoked. I would ask that bond conditions remain the same, or at least give AP Enda time to respond to that change bond.
Right. I think I'm going to do that. I'm going to deny that request at this point.
Yes, Your Honor.
Court calls case People versus Austin Shepherd.
Morning, Your Honor. Raymond Cook for the people.
Sherilyn Foster Tucker on behalf of Austin Shepherd.
Austin. Your name? Austin Shepherd. Yeah.
Your Honor, this is the date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed this case dismissed. That's on defendant's motion without prejudice.
Thank you, Your Honor.
Thank you.
Thank you. Have a good one.
You do the same. Court calls case of the People versus Taija Wynn.
Morning, Your Honor. Raymond Cook for the people.
Sherilyn Foster Tucker on behalf of Tiaja Wynn.
Tiaja Wynn.
Thank you.
Your Honor, this is the date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed this case is dismissed on motion without prejudice.
Thank you, Your Honor.
Court calls case of the People versus Rashad Ahmad.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. Sam Bernstein, standing in for the attorney of record, Charlotte Steffen, and on behalf of Rashad Ahmad.
Good morning, Your Honor. That's with your permission, sir. Yes, sir. All right.
Your Honor, this time the people are unable to proceed.
Your Honor, we move to dismiss.
People being unable to proceed this case is dismissed on defendant's motion. That's without.
Thank you, Your Honor.
Thank you.
Have a good day.
Go on. Court calls the case of the People versus Israel. Diego Guerra.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. Joseph Hall appearing forward on behalf of Mr. Diego Guerra, who is approaching. And for the record, Mr. Diego Guerra, if you could, I was going to ask you to pull the mask down, but to state your name for the record, please.
Israel Diego Guerra.
Thank you.
Your Honor, this time the people are unable to proceed.
Defense would move the court to dismiss, Your Honor.
People being unable to proceed this case is dismissed. That's without prejudice on defendant's motion.
Thank you, Judge.
Court calls the case People versus Jacob Grammatico.
Your Honor, Raymond Cook for the people.
And good morning, Your Honor. Joseph Hall appearing forward on behalf of Mr. Grammatico, who is approaching. And Mr. Grammatico, once you're here, if you could state your name for the record, please.
Jacob Grammatico.
Thank you.
Your Honor, this time the people are unable to proceed.
Defense would move the court to dismiss, Your Honor.
People being unable to proceed this case is dismissed. That's on defendant's motion without prejudice.
Thank you, Judge.
Thank you, Your Honor.
Is that it for you?
That is, Judge.
Wow. No, Your Honor. Continue, sir. Court calls the case People versus Caleb Kasham.
Morning, Your Honor. Raymond Cook for the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, I spoke to Mr. Kasham this morning. He put Monday's date in his calendar, but he didn't put today's date in his calendar. He's on a job site and cannot get here this morning. And as my knowledge, this is the first time he has failed to appear. So I'm asking if we consider an adjournment in this matter.
Your Honor, the people were able to proceed this morning. The victim did appear. We have since excused him once we learned the defendant would not be here. I would leave it to the court's discretion. Bench warrant or adjourn.
Let me add one additional thing, Your Honor. An offer was made today for the first time in this case, which obviously we would have had to discuss.
Is he going to take that offer? I mean, I'm not carrying this over because he forgot to put it in. I gave 2 dates and everybody else remembered them.
All I can do is represent what I know to be true, Your Honor. As far as taking the offer is concerned, he doesn't even know the offer because I haven't discussed it with him yet.
Well, I'll be here pretty much the rest of the day. I don't know how long Mr. Fitz's going to be here. If he can get here, he can get here, but I'm not.
Well, I already said that to him when I spoke to him, and he said he's on a job site and can't get here.
Bench warrant will issue for defendant failure to appear. Bond will be set to amount of $10,000. Cash as surety. I won't issue the warrant until Monday, 13th.
Right, thank you, Your Honor.
Court calls case People versus Kareem Omar.
Morning, Your Honor. Raymond Cook for the people.
Your Honor, Joe Simon on behalf of Mr. Omar. State your name, please.
Kareem Omar.
Okay. This is the day and time set for the final settlement conference. The people are able to See, it was offer extended to the plea under 7694A. My understanding that offer has been declined. This is Ms. Dennis' case. I can't represent that offer will continue past.
Waiver.
That's what I was about to say.
All right. Sir, you signed this waiver of trial by jury?
I do, yes.
Pardon?
Yes, Your Honor.
You did? Okay. And you understand that you have a constitutional right to have this matter tried before a jury?
Yep.
And by signing this form, you're waiving that right?
Your Honor, yep.
All right. People also waive their right?
Yes, Your Honor.
Based upon the statement of counsel, and defendant court will consent to have the matter tried before without a jury. Non-jury trial in this matter will be set for
April 29th.
Oh, I thought this was the 27th.
Oh, I'm sorry. April 27th.
Thank you.
April 27th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Bob, we'll continue.
Thank you.
Court calls case People versus Ontario Robinson.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Sam Bernstein with him on behalf of Mr. Robinson. Mr. Robinson, can you please state your name for the court?
Ontario Robinson.
Being next step for final settlement. Well, it may be also considered sort of an adjourned motion hearing. This is the case where the law firm partner, necessary witness, said it's quite unavailable. I have not been able to maintain contact with him since the last time over a month ago that we were able to establish contact. I don't know if he's going to be available in the near future. This has already been adjourned at least once on the people's request. I don't believe I can in good faith ask for another adjournment. I would just represent that when that trooper does become available, he would likely reauthorize the case if it were to be dismissed.
All right. I understand that, Your Honor. It's just been like 5 months, so we would still move to dismiss.
At this time, because of those reasons, people aren't able to proceed. You're moving to dismiss.
Yes, Your Honor.
All right. Case is dismissed. That's without prejudice. You understand that, sir?
Sir.
Okay. And this case could be brought back. Okay. Thank you.
Thank you, and have a great day.
Same. Court calls case of the People versus Christopher Seelig.
Hang on, Raymond Cook for the people.
Your Honor, considered on behalf of Christopher Seelig, who is making his way to the podium now.
Your name, sir?
Christopher Seelig.
For the Senate, unable to proceed.
Your Honor, I would make a motion to dismiss on behalf of defendant.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you very much, Your Honor.
Court calls case of People versus Aaron Bucko.
Conrad Siller on behalf of Pittsfield Township.
Ron Brown appearing on behalf of Mr. Bucko, Your Honor.
Aaron Bucko.
All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
All right. The defendant in this case is going to be pleading guilty to the charge of operating while visibly impaired, and that's the added count 2. Upon a successful plea to that charge, count 1 would then be dismissed. That's the court's full understanding of the right.
That's correct, Your Honor.
Yes, Your Honor.
All right. May I have him sworn?
You sound affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yeah. State your name, please. Aaron Bucko.
Sir, it is this court's understanding that you're going to be pleading charge of operating while in. That is a misdemeanor, punishable by up to 90 days in jail, up to a $300 fine plus court costs. Court to order any rehabilitative services or community service the court deems necessary. Could order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency government. Understand?
Yes, sir.
Understanding that, you still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
Signed an advice of rights form, is that correct?
Yep.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights that are contained on that form.
Yep.
Yes. You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
Sure.
You're doing this voluntarily and of your own free will? And also because you believe that you're guilty of this offense? September 7th, 2025, the location of Glencoe Hills Drive, Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle? Yes, sir. All right. Prior to operating that motor vehicle, did you consume intoxicating liquor? What'd you have and how much?
That I'm not exactly sure.
0.223 were.
Yeah.
Were you stopped by the police or was there an accident?
He's passed out behind the wheel, but the engine running, so he was operating technically.
So is that correct, sir?
Yes, sir.
All right. And the police did arrive?
Yes, sir.
And you were arrested? You were taken to the hospital for a blood draw?
Yes, sir.
And the blood draw netted results that your counsel just indicated? All right. You don't have any reason to dispute those blood test results, do you?
No, sir.
Take everything into consideration on that date and at that time. Do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, sir.
All right. Counsel, I do have to advise you, sir, between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rule, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant's referred to Von Schwartz for alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2026, 12 noon.
Bond continue.
Bond will continue, sir. Stop down at my probation department before you leave the building and get it started.
And make sure you give them this so they know you.
Court calls case People versus Frank Hearns.
Honor, it's still around Pittsfield Township.
3 doors down.
Frank Hearn.
Frank Hearn.
What are we doing?
Plead double park.
That's correct. Yeah, actually, the parking. He has filed an appeal with the Secretary of State.
Mr. Hearn, do you admit responsibility to the fact that on July 26, 2025, Campus Parkway in Pittsfield Township, that you double parked the motor vehicle?
Yes.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can you get that paid?
Can you get 60 days?
Pay it by June 30th. 2020.
Thank you. Thank you.
Thank you.
You're welcome.
Court calls case People versus Mars and Morton.
Honor, it's still around behalf of Pittsfield Township.
Ron Brown appearing on behalf of Mars and Morton. Gotta take it down.
Gotta take all that off.
Double parking. So we talk.
Mm-hmm.
All right. Your name?
Marsley Morton.
Okay. What are we doing?
I'm going to move to count 2 double parking, Your Honor. Accept the admission and this original charge.
How long you need to pay?
Yep. Well, sir, do you admit responsibility to the fact that on or about date of August 6, 2024, Packard Road, Pittsfield Township, that you double parked the motor vehicle?
Sir.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can you get that paid?
60 days.
Paid by June 30th, 2026. Thank you.
Thank you.
Court calls case People versus DeSure Bond Sanders.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Andrew.
Your name?
Ezra Bond Sanders.
Your Honor, at this time, the people are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you.
Thank you. Court calls case People versus Robert Bowe.
Ron Brown appearing on behalf of Mr. Bowe.
Take care, Connor. Your name?
Robert Bowe.
Your Honor, at this time, the people are unable.
Move to dismiss, Your Honor.
Being unable to proceed, this case dismissed without prejudice. Thank you.
Thank you.
Court calls case People versus Juwan Campbell.
Morning, Your Honor, Raymond Cook to the people.
Ron Brown appearing on behalf of Campbell. May I check the hall?
Sure.
Watch the other. No answer, Your Honor. Can you pass?
No. Bench warrant will issue for defendant's failure to appear. Bond will be in the amount of $10,000 cash. Warrant will issue immediately. Court does call the case People versus Austin Ingram.
Your Honor, Raymond Cook to the people.
Ron Brown appearing on behalf of Mr. Ingram.
Your name, sir?
Austin Ingram.
Thank you.
Your Honor, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without.
Take care.
Thank you. Court calls case People versus Alicia Calloway.
Morning, Your Honor, Raymond Cook to the people.
Ron Brown appearing on behalf of Mr. Calloway, Your Honor. May I approach with the prosecutor once she introduces herself? We don't need to approach.
All right.
Introduce yourself.
Alicia Calloway.
Thank you.
Your Honor, people are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Thank you.
You're free.
Court calls the case People versus Carlos Mack.
Morning, Your Honor, Raymond Cook to the people.
Ron Brown appearing on behalf of. Your Honor, may we approach very, very briefly?
Very briefly.
You have us driving left. Driving left.
Hold on. Yes.
Sign right there for me.
I was told to get him there.
Yeah.
Yeah, so I'm trying to.
Yeah, you're trying to get it, but
Yeah.
it's better than what you originally charged.
I was. Oh, okay.
Here's your receipt showing. But you,
Form I have it.
Yeah, no.
Defendant will be pleading guilty to an added count 2 of no operative person, misdemeanor, by up to 90 days in jail, $100 fine plus court costs upon his third count 1 would be dismissed. That's court's full understanding.
That's correct, Your Honor.
yes, Your Honor.
May I have it sworn?
Right here. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
That's correct.
State your name, please.
Carlos Mack.
Sir, it is this court's understanding that you're going to plead guilty to the charge of no valid operator's license on person. That's a misdemeanor, punishable by up to 90 days in jail, $100 fine plus court costs. Do you understand that?
Sir.
So wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
That is correct, sir.
You signed an advice of rights form, is that correct?
One of these You signed one of these before.
Yes,
All right. Any question regarding any of those rights?
no, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
That's correct.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I am.
Okay, were you on probation at this time?
I am right now.
Of this? Of
Nope,
this
it's
event?
time of the-
Oh, no, no, sir. No, sir.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce?
No, sir.
Doing this voluntarily
That is correct.
and of your own free will,
That is correct.
and because you believe that you are indeed guilty?
That is correct.
On October 18, 2024, at the location of West Michigan Avenue near Clover Lane Drive, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
That is correct.
Were you pulled over by the police?
That is correct.
And did they ask you for a driver's license?
That is correct.
And were you unable to give them a valid license?
That is correct.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed. Anything either of you want to say before I impose sentence?
Nothing from the people.
He's made some recent payments. He's trying to get his license, Your Honor.
Sentence of the court, $250 fines and court costs. I'll suspend 90 days in jail. When do you think you can get that paid, sir?
The 250.
90 days?
Yeah, give me that. Can I get 90 days?
Jail?
No, not. No, sir. No.
I didn't know what.
No,
I just asked you.
no.
And I said, and then
No, sir.
asking me for 90 days.
No, sir.
90 days to
I
Uh,
pay.
had no reaction until I said that. He's cool as a cucumber. I said that. Oh, no.
I got pickled on that one.
June 30th, 2026.
I have a quick question, Your Honor.
Yes, sir.
Because I was trying to pay for my reinstate my renewal like today or tomorrow for my license. I got to pay that fine on top of that before that.
We're trying to pay what?
For my license, my reinstatement renewal.
We're trying to pay the reinstatement.
The 125?
Yeah.
The 125. But the 125 would be paid at the Secretary of State.
Right. No, correct. That's what I'm saying. Because now I got this fine on top of that. So I have to pay the fine first.
Okay, so the way I think it works is you can pay that 125 at the Secretary of State, but then don't not pay this because you're going to you'll get a suspension will happen.
Right. What I was saying, because I made a payment yesterday, but I couldn't pay my reinstatement renewal because I had to owe the ticket that I had to pay on.
Was it this ticket?
Yeah.
I think
That's what I was license for that. Oh, I see. It's better than yeah.
Yeah. Sir, it seems to me that you got a suspension from a ticket from 2023. This court.
Is that 241-1404?
The ticket number, it looks like it's a suspension from an operating while intoxicated. Our ticket number is 231-0445.
Yeah, that's what I was paying.
Yeah, you pay.
And then you have another one.
Yeah, that's the full case.
Well, that's off of the same one.
Yeah.
So it looks to me like there was a suspension, but you may have done something and if we're suspended to April 2nd of 2026, which may be why you're able to potentially pay your reinstatement fee. You then have a ticket Out of 14B.
Here. You're on street, you have. On Whitaker.
That, well, no, that, never mind, because your suspension was ended in 16. It might, well, that's older, so it might be this one.
That's the only one.
They did it, but there's an adjudication at least on it. Okay. So, I don't know what the Secretary of State will say. You can tell them you pled to a no ops.
Okay.
And see if they'll let you pay it.
All right.
It's got time to pay this one.
Okay.
All right.
So,
all right.
All right.
Thank you. Court calls case People versus Nicholas Meath.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Nicholas Meath. Nicholas Meath. Move to dismiss the charges.
People being unable to proceed, this case is dismissed without prejudice.
Thank you. Thank you.
Court calls case People versus Robert Lee Redding.
Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Robert Lee Redding.
Your name, sir?
I also Robert Redding.
Your Honor, this time the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed
Thank you.
without prejudice.
Thank you.
Court calls case of the People versus Jeremy Rice.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Jeremy Wright.
Your name?
Jeremy Rice.
Your Honor, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is without prejudice.
Thank you.
Court calls case People versus Nabia Smith.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Smith, Your Honor.
Good morning, Nivea Smith.
Your Honor, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed as without prejudice.
Thank you.
Thank
All right, thank you. Court calls the case People versus Ryan Studeville.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Studeville. Can I check the hall?
I guess yes. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. Warrant will issue immediately. Court calls the case People versus Michael Taylor.
Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Taylor.
Good morning. Your name? Michael Taylor. Thank you.
Your Honor, people are unable to proceed.
Move to dismiss.
For being unable to proceed, this case is dismissed. That is without prejudice.
Thank you. Yeah.
Court calls the
Get
case.
his bond refunded now?
What, he wants his money back?
Just like this?
Yeah.
He can't have no money.
He wants his money back?
Yeah.
How much you pay?
I got bills. Take your receipt and your ID to the county.
Okay. They'll see that it's dismissed. They should be able to return your bond.
Do I need to present a receipt
If you got
when they look it up?
You have an ID?
Yes.
They may be able to do it with the ID.
Okay. Thank you, John.
All right. Thank you.
Thank you.
You're welcome.
Court calls the case People versus Cortez Triblet.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of
Morning. Your name?
What's that, Triplett?
Your Honor, people are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is without prejudice. Thank you. Does he want his bond back too?
Want your money back?
He didn't pay anything. Should have said yes. And then court calls the case, People versus Joseph Williams.
Ron Brown appearing on behalf of Mr. Williams.
Josie Fitzgerald Williams.
Thank you.
People are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without.
Thank you.
All right, yes, sir.
Thank you, sir.
Court calls the case, People versus Delia Williams.
Morning, Your Honor, reading for the people.
Ron Brown appearing on behalf of Mr. Williams.
Hi,
Your name?
Kylia Williams.
Your Honor, the people are unable to proceed.
Move to dismiss, Your Honor.
Who's that with you? You.
My mom.
Your mom? Okay. I knew it had to. She looked worried. All right. People being unable to proceed, this case is dismissed. That is without prejudice. All right. Thank you. Court calls the case, People versus Alberta Wilson. One case.
Ron Brown appearing on behalf of Alvaretta Wilson, Your Honor. I've called her and she lives in Detroit.
And she also has another warrant outstanding.
Okay, we have an 18-30013. You, Willie Franklin Cowart Jr. And there was a hearing held about a year ago, and you pleaded true to some reporting issues, and you have been on probation since 2019. And this is an update on status, how he's doing, I guess, from probation. So I guess the question is, how is he doing?
He's doing good. Last time we were here, you discussed possibly early termination for him. You just had the stipulation that he test negative for methadone moving forward. So he submitted 2 drug tests, one on 220 and one on 320. Both were negative since our last hearing.
Good job.
I also believe the last status hearing we had in January was to make sure that he had paid all restitution. And it's my understanding that it's all paid at this point.
Okay. So what shall we do?
Up to you, Judge.
Actually, it is, but I'd love to hear what everyone has to say. I know what the defense says, but y'all are we need two advocates, but actually at the end of the day, probation is the neutral person. And what do you think?
Well, he's done what's required by the courts to him for the most part. And so if that is something that everybody is on board with, I'm okay with early termination.
What do you think, Mr. Coward?
Yes, sir. I agree with you.
I'd have been shocked if you'd have said otherwise. You obviously, your mental faculties are sharp today, obviously. What do you plan to do now?
Well, sir,
when and if this gets off your back?
yes, I plan on getting a stable income and just
Doing what?
stable. That's okay. That's kind of up in the air. I broke my back in two places, so the work I used to do is kind of
no more heavy lifting.
Yes, sir. So I got to work my mind instead of the body. So it's kind of taking just more. So it's kind of
So you're going to, I guess, apply things like that?
Yes.
Okay. Well, at least you'll be able to put on your application you're not on probation.
Thank you, sir.
Okay, we'll get a termination of probation over to me and I'll sign it.
Thank you, Judge.
Good luck, Mr. Counts. I see Nakia Lewis was reset.
Yes,
right, Brent? Okay. And Thaddeus Jolly, this was reset to next week. Is that right?
Yes, Commissioner. Right?
Yeah, there's a.
Hey, not so fast, John. I've got it looks like this is an add-on Christopher Chambers. That's you.
I'm running full. I didn't make those and they did bring them over. So we couldn't do anything with it even if we wanted to. But
what was he going to do?
He was somebody who was tried to plead this past week. And there was always some issues of competency and he kind of acted up a little bit here and you said no to the plea to set it for a hearing and told us to be ready by Friday.
So you should have two dismissals, one for the MTRP and one for the new case. When you're accused.
Oh,
yeah, it's
well,
wherever your tablet is.
Yeah, I don't know where it is. Do y'all have it?
No, it's somewhere.
Yeah, how about you? Did y'all check under the chairs? Is it under that guy that's laying down?
Yeah, on this court, it may have fell.
Yeah,
we may not be
under him.
Right here.
Okay.
There should be a new case in emotional abuse.
Yeah, yeah.
I guess you're still on probation.
You can't make this stuff up. It really happens in this room. Okay, it looks like two cases, 24 CR 747, 24 CR 2317, each style, the state of Texas versus Christopher Chambliss. There are motions to dismiss in each case without objection.
No objection.
I shall sign these on this 10th day of April.
Because I got one line and you're ready to go. See you guys have been. Thanks, good morning. Be careful. Yeah, thanks. I'm gonna miss you, Brent.
Yeah, wait till you leave and see what they say. Good. That's wise.
Get on YouTube.
You can't watch it.
Return again. Brent. No. He's been served. So definitely more easy. Yeah, so I'm in Africa. Part of every case. Yeah, yeah. You're ever solving. No, yeah, 2 weeks. No, that's short. That's short. Not very long. I think this was 4 from the citizens. Okay. So came up on here. That is really shorter than his normal ones are. Yeah. Sometimes like 6, 7, 8, 9 months. Good. It's good to be key. Thankfully, it's nowhere near with most things. But this writing is type of work, that might be probably not all that area. And I have a friend that does what he did, and you just have to do a certain things on the thing. It's like in these are that's way
Which gymnastics to get it done. Yeah. I mean, everybody has a problem with everybody's complaining about it.
It's kind of a pain. All right, well, on Monday. Have a good
See you, buddy.
You too.
Yeah.
All right.
I feel better about saying, like, you need to out today.
Yeah. That's your last meeting.
Yeah. Good. All right. All right.
Okay, what attorneys are you here for a case? Is it Jack C. Pad?
Yeah.
Okay, come on up, please. Thank you. Miss Lay?
Yeah.
Uh-huh. Ciao. 25 CR 1341 is called, the state of Texas versus Jackson Pond. Yes. I hope I'm saying that.
Yes.
You are here, and you are here with your attorney, Miss Lai. Lay, is it Lay or Lai?
Lai.
Lai. And the state's attorney, Mr. Ham. And this is an announcement. As you know, you're charged with the 3rd-degree felony of theft, which carries with it, if convicted, up to 10 years in prison. So it's very serious. Let me ask you, are you still living in Las Vegas?
Yes.
Okay. That makes one of us. 9235?
Yes.
Okay. So what are we going to do today? An announcement. What's our plan? Are we trying to resolve it without a trial?
We've had some discussions, Judge. I've given an offer.
Okay, it's over half a year old. So what do we do?
That's
Trying to conferring with the prosecutor.
the last few I saw.
Ma'am? I'm sorry.
Trying to conferring with the prosecutor.
Okay, what do we do next? What's our next?
Judge, there's co-defendants. The other one is scheduled to make an appearance today. I've asked for them to stay on the same docket. If, probably because of the age and the type of case this is, I would suggest placing it on the trial docket.
Again, we go on the trial docket, we go to trial, and that's the way it is. Now, it's a backlog. But we tried, according to the internet, more trials than anyone else has ever tried. So that's what we do, is try cases. We put it on, we'll just I don't want it to throw on the trial docket and languish, and then.
If you want to give them one more setting to determine.
Well, it's been a half a year. Everybody's had enough time to figure it out. You know
I
which
just
way
made
you
a
want.
formal offer today. If you want to give them full time to consider.
What is the plan?
I've offered them a cap of 5 years.
Oh, I see.
Does
the defendant have a criminal history?
He does. He's actually on deferred probation out of Harris County. And
Okay, it's deferred. He's not been convicted.
no, sir.
Right?
Yeah.
Okay. For what?
The
Curious.
actual charge is tampering with a government record. He ended up pleading. That was the original charge. He ended up pleading and took it as an attempt to commit. Resulted in it being a felony 3rd degree. He was placed on 4 years probation. That actually occurred 4 months before this particular offense, and that's the reason why I'm not offering him probation.
Because he was on probation.
Yes, sir.
When this allegedly occurred.
Yes, sir.
I thought that sentence.
You have to. No. Stuff like this. Stay on the side of the thing. If you go over there, you're gonna get one. So they so he paid 20 votes.
I'm a little fuzzy about something here. I've got this packet of papers here dated March 17th about the defendant's supervision in Harris County, Texas. And I'm not sure, I'm reading this. I'm not sure how, have you read this?
No, sir, I have not.
I'm not sure how to take this. I'm not sure if I'm happy or concerned about what I'm reading here. And it may be just the way it's typed by the person who types, who may not be appreciating the way the wording is used, but everybody gets to read this. That's in the file, and it's concerning monitoring. And it's the way I read this is almost as though Harris County is going to dictate to me how the defendant should be monitored, which is not even close to reality. I don't understand why they would infer that. Maybe I'm reading that wrong, but this court's not going to be bound by anything Harris County does unless this court approves of it. And I don't understand. Maybe that's just the way they write things, and it can be read incorrectly. But are there any issues about any type of monitoring that we need on this? Oh.
Judge, I'm looking for the false number.
What bothers me about it is that the defendant comes into this city, is not from this city, from Las Vegas of all places, and is according to the allegations in the indictment, attempting to embezzle or steal money in a scheme of deception on the west end of the town here. And there are some things I just don't understand about why someone from Las Vegas decides to come into this city to victimize. That's a bothersome thing. I'm not through, please. And I want to know as much about him so that the people in this city, this county, are safe from outsiders who decide that we are ripe for victimization. I don't like that. And we're not talking about a small amount here. This is a third-degree felony theft, which means the value is $30,000 or more. Plus, we've got a Harris County case that is pending where the defendant had a criminal matter dealt with there. Were there any? It's been a half a year. Nothing's moving. I'm going to move one way or the other on this. I mean, are there any conditions that we need to add to the defendant's pre-trial supervision to ensure the safety of the community?
I apologize, Judge. I don't know what the current conditions of his bond are.
I don't either, really. The only thing I know is that there's a $100,000 surety bond here in the file, but
So between the two defendants, this is the only individual that has a record. And I have genuine concerns that this offense is committed while he just started a probation out of Harris County. I do appreciate that they at least ordered a monitor.
So what was the,
like you, I
what was
don't
the
like them
offense?
trying to dictate your term.
Yeah, what was the offense out of Harris County again?
It started out as a second degree tampering with records, but he ended up pleading to a third degree in attempt. And they placed him on 4 years deferred probation.
Can you tell me a little more? What record? What are the records?
I don't know anything about it, Judge. I just know what was reported to me on the NCIC report that we have.
Do you have an indictment from it?
No, sir, I do not. I don't have anything other than a cause number and what the end result was. I'm going to need to reach out to Harris County to find out more information.
You do have a GPS device on you. Who's monitored? Is that being monitored out of Harris County or?
Yes, you should speak to the bond conditions judge that we have a system, as you can say, who's monitoring it.
He used to have a GPS from Jefferson County, and then
Yeah, two. He ended up having two of us then, right?
now he only have one because the Harris County cut off the Jefferson County one.
They did what?
They cut off it. Here's the thing, Judge.
Yeah.
Since
Let
he
me
was
ask you this: why? We're going to get into this. Did they do it without our permission, without our knowledge? That's kind of rude if that would happen, and that would be very unprofessional. But I don't think that's what happened.
this
And I can understand you don't have two. You don't need two GPS devices if responsible monitoring is being done by one or the other. But the point is that we don't know what Harris County is doing. They could dismiss their case tomorrow, and then the GPS falls off, and then we don't have a GPS. What I want to know is to make sure that the defendant is being monitored at all times. And if there's a change in the monitoring, we have a professional courtesy, just a right to know, since everybody is, Harris County is aware there's something here in Jefferson County that's pending, and us for Harris County. That's all. Just want to make sure that we're all on the same page. And if there is a change, all parties are to know about it as soon as possible, so that he doesn't fall through the cracks, as it were. That's all. And that's not a lot. That's not anything to ask for. That's only the right thing to do.
Maybe as far as to his probationary terms, where those are monitored, whether that's here in Harris County or if it's been transferred to the other states.
I don't know. I don't know the answer to that. Does he come to Harris County to report, or is he courtesy supervision in Las Vegas? Do you know? From Harris County. Did Harris County transfer it over to Las Vegas for Las Vegas people to monitor? Or does he have to come into Harris County every month? I don't think that would be logical. Right?
Yeah. I think he was monitored by his probation was transferred to Las Vegas.
Okay.
Yes.
I mean, courtesy supervision, that's normal. Okay. So they're the ones, Las Vegas monitors. The only issue is that the monitoring from Jefferson County needs to be aware that if there's an issue, they and Las Vegas monitoring need to communicate and have open lines of communication, so that if there's a change in the status in any way, we don't find out about it a year later. We find out immediately, since Jefferson County. And I'm going to ask you if you'd be so kind, ma'am, to make sure that is done, because I can say, I'm not going to let him be cured. I'm going to do it now, but as long as we stay in communication. If we don't, then he's going to have to come into Jefferson County every month to report, which I'd rather not do. But I have. But we're not aware of where the consistency and the communication lines are connecting with each other. Everyone needs to be in the same, on the loop, please. And we need to get this accomplished immediately so that there's not a lapse in our supervision. Because if something happens, if he's not following the rules in Las Vegas, how do we know? We have to trust Las Vegas to tell us. And if they're not going to be willing to do that, then he's going to come over here and report every month, which is not practical.
Yes.
That's not what I want to do.
Thank you, Judge.
Then let's get it 2 weeks to figure this out, okay? And I just want to know. He didn't have to be here. Everybody needs to know about everybody being on the same page.
The Harris County probation is 4 years probation, so they're not going to dismiss the case in a short time.
Understand?
Yeah. So he will
Understand, but I just don't want.
Yes.
I just want Jefferson County to make sure that we know if something happens in Las Vegas, we don't find out about it a year later. We need to know immediately if it affects our supervision over him. And what do you want to do on your next event? What's the next event? Do we put it on the trial docket, or do you want a few more weeks to try to figure this out? It's your call. Because it's a half a year old, but I can give you some more time.
How about reset one more time?
Okay. Yeah. How much time?
1 or 2 months, please.
How about, is 5 weeks good?
Yeah, no.
Okay.
Yeah.
Okay. We'll reset 5 weeks. Thank you for the announcement.
Thank you.
Okay. Gregorio Flores.
You choose stuff. Good morning, Judge.
Judge, I'm looking at this file, and this was assigned to somebody else previous, who's no longer with us. And the first amended motion to revoke probation, which is alleged in this January 28, 26 administrative hearing, has not been filed yet. So we can either deal with it without filing it, or I'll get it taken care of before
What's the master plan?
So Mr. Flores blew a .068 into his interlock, and he didn't submit to a follow-up test. So it's unable to determine if he was using alcohol, if he drank alcohol, or if it was an alcohol contaminant. I'm recommending that he obtain a SCRAM device in lieu of the interlock, so it's going to be a continuous monitoring of his alcohol consumption at any.
Okay. So when we do a 068, what's the normal protocol? What are they required to do as mandated by their terms of release?
He would have needed to submit to a follow-up test, because if it was alcohol, it would have stayed.
Okay, and they know that.
Yes.
Why didn't you?
Yeah, I was my first time.
Are they told?
Yes, Mr. Flores should have known.
How should he have known?
I addressed it with him. And
you did?
Well, when I mentioned it, that I was going to be filing this first amended, he said that he should have admitted to knowing that he should have submitted to the follow-up test.
Why didn't you do it?
I didn't do it at the moment. I was, it just turned off. I just turned it off, and I didn't turn it back on.
Why didn't
I didn't react it because I've been having the interlock for over 2 years. I've been having it for 2 years exactly. So it's just, the first hit, I didn't think nothing of it, and I got complacency. And there's no excuses of what I did or what I didn't do, but I'm just.
Well, it doesn't make any sense. It's just, you made a choice not to follow the rules.
No, sir.
You didn't know you were supposed to have a follow-up? He says you. No, he says you were told
of the test itself.
Yeah. Yeah, 068. And there's supposed to be a follow-up.
Yes, sir.
But he knew that.
Yes, sir.
When was he told that if that happens, he has to have a follow-up? Who tells them that? Because I don't know practically how that works. I just know there were requirements. I just don't know how they're conveyed to the defendant.
He should have been notified whenever it was the analog.
Ma'am? Oh, well, who would have done that?
You have it through Smart Start.
Smart Start.
Well, they didn't tell you?
Honest to truth, Your Honor, I just didn't think of nothing of it, to be honest with you. I didn't react to it, towards it, All I said when I blew, it said warning, and I was just,
Is this just being held open by the MTRP, or when does his expire?
27th. February 27th. It was extended 2 years to align with the DWI he got.
Well, thing is, the conditions of probation that he signs and he was aware of and that are ordered, when it comes to alcohol, it states you don't become intoxicated. Doesn't say don't use any alcohol. So how does he know at a 0.68 if it's not deemed intoxication that he has to do a follow-up? Where's that ordered?
It's part of the conditions of the interlock. So
Where are those conditions of interlock? I don't have them. I never have seen such a
not
thing.
necessarily conditions, but the instructions. So
Well, I've never seen such. I don't know.
This is how to-
This is what he gets? I'm sorry. And everybody else gets?
no, sir, but that's how to read the report. So it says that without a follow-up test, you can't determine if it was alcohol or an alcohol contaminant.
And where these, for his fact situation, where does I think that fall in the list of things? If it's a 0.068, where in that document, where would a person on probation go, this says I've got to do this next? I'm not talking to you. I'm talking to her. And so that there's, we got an issue here, and if it's a gap that we need to fill in, we always see a unique set of circumstances.
I think the first issue
what was his requirement when it's a 0.68 of anybody?
To submit to a follow-up test.
Where does it say that?
He would need to submit to the follow-up test, I think, to operate his vehicle.
And he did the 6 hours later, though, didn't he?
6 hours later.
6 hours later, he did it.
The vehicle is frozen for 6 hours. Is that right? Is that what happened?
Yes.
Well, so what'd you do? You sit around or?
No, I
waited for a few hours later and come back and started?
No, sir. To be honest with you.
Yeah, that'd be a good thing.
Whenever you blow, it basically just states warning. Puts a warning. That's it.
Well, she says that it freezes. You can't start your car for 6 hours. Is that right?
No, wouldn't be able to start the car until he blows again without any alcohol in the breath. He would need to blow a 0 before he could start the car.
But that's the point, though. The car, it was frozen, right? You couldn't start it immediately.
No, sir.
So what did you do?
To be honest with you, Your Honor.
Yeah, be honest with me. Yeah, what happened?
I just kept on living my day the way that
and then went back to the car later to start it?
Yes, sir.
Like 6 hours later or something?
Yes, sir.
Okay, so you were at home?
Yes, sir.
See it.
Okay.
Well, I show it was held in advance, and that we were setting it up for review. It's still
figure out how that practically works.
Judge, here's the problem I have, and I agree that there's a violation here, but this man was placed on probation in February of 2025 for 10 years. And we're past that 10 years.
You said that that was
2015, sorry, 2015 for 10 years. And we're past that.
Was there a motion filed?
And there was a motion filed and it's held in advance, but you still.
As it was extended 2 years.
Yes, but you can't. I cannot file a motion once even if it's held in advance, because that original probation has expired. It doesn't hold it open for all the violations, I don't believe, according to the law. Now, he did violate his probation that he's on a misdemeanor that he got in 2025, I believe, for 2 years, that he still got a violation on. He's got to deal with down the hall. But I'm not sure that what we can do with this.
Was it ever actually extended? I mean, I know it's been held in advance the whole time, but I don't see it on the portal. I don't see it active.
13/15.
Oh, I didn't see one in here. I was looking. It just says it's impaired plea held in advance back on May 14th to 25. June 15th says held in advance review.
I guess it could have been a hold line.
Yeah, but I don't know if you can extend it for 2 years on a 10-year probation on the deferred for injury. You can with like financial stuff. Sure. You go past 10.
I used to think you could, and I think that I learned you could.
Well, you see, it just, as long as a motion is filed before the 10 years, that tolls things.
It tolls giving him a sentence, but it does. I don't think we can't amend after it's expired or would have expired. We cannot amend a motion to revoke. We've been through this. Yeah, we've been through this with we've been through this.
So who's amending the motion to revoke?
Well, we've asked for a first amendment. Otherwise, we don't have anything really. We got to the administrative hearing here. I guess you can. I don't know if you can do it for administrative violations or not. I'm sure. That's my problem I have is.
I'm not sure this is the right time. We're going to stop and do research.
Yes, sir.
Could everybody look into it?
Yes, sir. We have just a week or two to kind of look at it.
Yeah. You live in Grove?
Yes.
Oh, okay. You're local. No, I don't. I'm going to come back next week. Can y'all look into it? Michael?
Yes,
Mr. Laird, can y'all look into it and come back next Wednesday?
Yes, sir.
And see what next Wednesday? Yeah, it's Wednesday. Good to hear. Thanks. Because I want to know, I mean, if he doesn't need to be on probation any longer, that's another thing.
Yes, sir.
We don't need people on probation longer than necessary. My theory. Okay.
That's it. No profession.
All right, I have. Where's Gregorio Renfro? Mr. Renfro? Gregorio Renfro, no answer. Gregory Renfro?
What?
Yes, thank you. No answer in the courtroom. I asked if they please call into the hall for Gregory Renfro. You look like Gregorio here.
See, that was Christmas.
That's right. That's. He still bothers probably down there.
No response to the name called here in the courtroom. No response to that name called into the hall. Defendant has failed to appear. A warrant shall be issued for his arrest. There is no bond. He is on regular probation. A warrant shall be issued for his arrest. And his lawyer's not here either. But should a warrant be issued for? No. And here's the issue. This was a sentencing hearing.
Yes.
I understand that. Katie Gloud, where are you? Katie, is that you? Is Reagan Minaldi your attorney?
I'm nervous.
I'm sorry. I'm going, you're so familiar. Where is
She called me.
Katie Glouds?
I don't know where she.
Is she outside?
It's not here.
Oh, okay. She's supposed to be here though, right?
Right. She would not feel.
Katie Gloud, there was no answer in the courtroom. I'm never feeling well in here. Generally.
It is very bad.
There's no answer in the courtroom. I asked the bailiff to call into the hall for Katie Gloud. What's the status? Good or bad?
She made a payment to it. Probation. She said the next thing I feel.
No response, Your Honor.
There's no response to that name called in the hallway. No response to the name called here. I'm just reluctant to order any punitive measures if she's doing well. Let's reset it a couple of weeks but she if she goes see a doctor, we need a doctor's report, but and you just make sure that
If you want to set it up Wednesday.
yeah, we'll set it for next Wednesday for the review. But her attorney didn't hear either, right?
I don't know if it's going to be here with it, just need a status update, Judge.
Daniel Moten.
I think I did that, Judge.
You okay there?
Sorry. Just a bad. Yeah, thank you.
And 13-18135 is called Daniel Gary Moten, and Mr. Moten is present with the probation officer. Okay, this is one of those where it's all about money, especially restitution. And this would have been ended long ago. Had everything been paid up, but there was restitution ordered in an amount over $60,000, and of course, the victims are remembered, and this court ensures that victims' rights are honored as best as we can under certain circumstances, but this one's a money thing. So how are we doing?
He's doing very well, Your Honor. He started out, like you said, $60,521.20 for restitution. He has paid in $25,070. His remaining balance of his restitution for $35,451.20. Since the last hearing that you all had, June 27th of 2025, you ordered him to pay $500 monthly. If he can pay more, do so. He has.
He has what?
Paid $500, and sometimes he's paid $1,000. This morning he paid another $1,000. So for 10 months, since your last hearing with him, he's paid in $7,000 until today's date.
Okay. And so what should we do? Reset it for another review? And
what I would recommend, Your Honor, is have another review within a year. and just see how it goes. If he misses a payment, then we'll notify the court, but he's been doing well.
Go ahead, Mr. Mo. Is everything continuing copacetic?
Yes, sir.
Okay, so you'll be able to make these kinds of payments pretty consistently.
Yes, sir.
It's just 35 months to go at $1,000 a month. That's 35 months to go, which is a little less than 3 years. But you can see the end zone from here now. It's not like you're trying to go 99 yards for a score. You're past midfield, as it were. So we're moving in a deliberate fashion toward the end zone. That's good. Many don't. Anything to do today?
No, sir. I will say that he does make more, like over 1,000 when he can, but at minimum, he's doing
That's all
everything.
he can do, and I'm very satisfied. The victim in this case, how is he related to you?
My father.
Your father. No. Well, I don't mean to be personal, but how's that relationship?
Very well.
Oh, y'all have rapport.
Yes.
Okay. Good. Sometimes this kind of thing can break a family apart, but well, good. No, I'm glad that is being accomplished too. And a family unit stays together. That's important. Okay. So what, 6 months?
I'd say a year, Your Honor. He lives about 3 hours away.
Year.
Yes, sir.
Or less if we could celebrate. But whatever you do, we had some people over my career as a judge here. Some people get antsy about trying to complete it, and then they get into a box. I had some person going out and buying hundreds and hundreds of dollars of lottery tickets. They never win. They could, but I mean, the chances are astronomical, but that's what they were doing to try to, and they were then just digging a deeper hole. So you want to keep working toward the end in a responsible fashion like this. Okay. All right, please get a resetting in a year.
Thank you, Judge.
Or earlier, if something can work. Thank you. I have a defendant, Xing Yang, with Brandon Zarate.
Keep in contact with your probation officer. We don't have our calendar set up for.
All right, thanks.
Okay.
Morning, everyone. Let's get your left.
Okay, there's these. So on Christopher Chambliss, we took care of that already, right?
Yes.
And John is gone. Okay. And of course, it's going to be hard to pronounce this, but I'm going to Xingshang Yang.
Yes.
Oh, okay. Ciao.
And this is my paralegal who's translating it all before it's sentence.
Okay. Mr. Zarate, as the defendant was indicted about a half a year ago, it looks like, huh?
Yes.
6 months for the third degree felony of theft. And we were here back in January, it looks like, right?
Yes.
And this was placed until April 10th today for an announcement docket. Where are we on all of this?
So state did turn over what I'm assuming is all of the discovery. There's one thing that is outstanding, and that's a phone dump. I'm not sure if that was actually ever done, but I do know the phone is still in the state's possession.
But let me ask one thing. The defendant lives in Las Vegas?
Yes, sir.
This is
In relation to the other defendant?
These are
This is the co-defendant. What were the odds of that if they weren't? Okay.
So my understanding is that's the only piece of outstanding evidence, if it exists at all. But other than that, I think I'm in a disagreement on the state's offer. My client's claiming his innocence, and we would like a trial date.
I don't want to separate these two co-defendants, Judge. The other one got a reset for 5 weeks to consider the offer. I prefer that they both stay on the same docket.
Well,
if we're going to set them for trial, that's fine, Judge. That's where I was at with the other, but
I'm going to set this one for trial, but it's going to be, when would the trial docket be?
I'm setting it to late summer at the moment.
Yeah. So the next one comes up in a month. If they can't resolve it, we'll set it for trial. I'd like to note it somehow that those two cases will be placed on the same trial docket.
Yeah.
And this defendant will require a Mandarin interpreter, if I remember my notes correctly, Judge.
I believe technically
I just don't know any.
My client does not speak English.
I don't know any. So what do we do about that?
I don't know the court's procedure on translators, but
generally the translators generally are Spanish here. That's 99% of translation is Spanish. And that's easy for us. Mandarin, no, I don't know any locally. Do you have any?
I reside in downtown Houston, but
you've got to have them there, I'll bet.
We do utilize translators for like depositions and stuff. So like we could obviously recommend a few, but at the same time, I don't understand if they're going to be able or want to travel. I'm sure there might be someone available.
Well, you get paid to travel.
Yeah.
But it'd be nice if it was Houston or within.
Yeah.
That I don't want to go get somebody from Las Vegas.
Yeah. I can email a list of potential Mandarin translators.
I can also deal with Master Word, Judge. We have a contract.
All right. So we got a ways. I'm going to set it though for trial then, but I want a review on the same day the other one is coming.
Thank you, Judge.
So the next setting will be with the other co-defendant.
And would that be pre-trial?
Yeah, we'll call it that if there's not a disposition. And Lacey will get you the date. Yes, sir.
Absolutely.
Thank you. All right, good. Anything else? Okay.
Not further. My client be excused?
Yes, sir.
I just need a signature on the reset.
Thank you.
Give us a second.
Is that it? Period?
No.
Yes.
This is 80 Cloud. You'll hear from May 15th.
Okay.
Yeah, that's with the other defendant.
Give me Katie Blount's file, please. Thank you.
So Dan, I'll just have to do all of the guns.
We called your name and you weren't here, so your bond was revoked. Huh? I called your names and you weren't here. Your bond was revoked. That's what happened.
Judge, on probation.
Yes, Your Honor. She was the one that the probation officer said she was doing well, so you didn't want to do any.
No, you got to be here though, so on time.
Yes, sir. No.
Ma'am?
I'm doing on.
Well, how'd you show up today?
Someone got in touch with one of my family members.
Oh,
in our
okay.
computer,
Oh,
on my way to work.
Good.
So
Good. So
Um,
Do you want me to call the officer back or?
you said she was paying well, Judge. We can just.
No,
If you want to send another statement.
what else? Well, while she is here on behalf of probation, have y'all told her she's doing well? Have y'all told her about early release for doing well?
I don't know what the officer told her.
Okay. Yeah, if you do well, I dismiss these cases early. And I can do it in a third, generally, in a third of the time. You've been on probation September 24th. So that's year and a half, a 10-year probation. A third is 3 1/3 years. So that's still a couple of years, a year and a half. A little over a year and a half to go before you can be considered. But if you're doing well, that's all that's important for us.
Yes.
We don't need people on probation who are doing great. It's the ones who aren't doing well. That's who we keep on probation. But in 3 1/3 years, and I just want you to know that so you can write it on the calendar to look forward to ensure that that is reviewed. But 3 1/3 years is, let's see, like January 28th. Less than 2 years away. So how often do you report? Once a month?
Yes, sir.
Mhm. Okay. Yeah, there was just this one issue that time about a location at 1 a.m. that I noted. That was weird in this motion to revoke probation. And then the public intoxication you pleaded true to. And then that's all fixed, I guess.
Yes, sir.
Okay. Yeah. Then just continue probation and continue doing well.
Thank you.
Okay. Yes, ma'am.
We'll have to set her up for a future court date if she has a pending MPRP.
Yeah, we're going to review it in 6 months.
Okay.
Okay. Get a resetting from this lady. Thank you.
Yes, sir.
Anything else? That's all? Great. Thank you. We're in recess. It's Friday. Have a nice weekend, everybody. And nobody passed out during the duck fingers.
All right, so let me try to take care of Mr. Goldstein because I'm going to want to talk to those two at back. So let's try to do this one. Court does call the case of the people versus Shante Wingard.
Morning, Honor Raymond Cook for the people.
Good morning, Your Honor. David I. Goldstein, appearing on behalf of the defendant. Ms. Wingard, please state your name.
Shante Wingard.
Court has before it a plea form that indicates that the defendant would be pleading to retail fraud in the 3rd degree. That'd be an added count 2. On a successful no contest plea to that charge, count 1 would be dismissed. And then defendant is agreeing to pay restitution, if any, and there's a sentence agreement on prosecutors defer. That's the court's full understanding.
That is a correct statement, Your Honor.
And ever sworn.
Yeah, I don't even know. Like, I wanted to get details on my probation. I wanted to get details on my probation before I even proceeded because I was going to take it to trial until I got details on how my probation was going to go, how long. I didn't get anything.
That will be done at the time of sentencing.
Yeah, I don't know that.
It can't be more than a year. I told you that. It could be less.
I think I want to just take it to trial. I'm sorry.
Okay.
Yeah. Maybe you may want to think about something.
Mhm.
I'll certainly talk to counsel, but they're offering you a 93-day misdemeanor.
Mhm.
And so if you're going to trial, you'd be going to trial under 1 year.
Okay.
Okay. I don't need you to make a decision. I just need you to understand that. I'm sure Mr. Goldstein explained that to you. I'll pass the matter and then I'll talk to counsel.
Okay.
In a minute, because I'm not that way. Can't do anything else because Mr. Brown is in there. So why don't I have Mr. Glick and Mr. Cookin back? Court's gonna all rise.
Thank you.
I think we can deal with Courtney Allen and Albert Williams right away.
Have you heard from Jonathan Irving this morning or lately, Mr. Cooper?
That was one, Judge, I've been talking to Mr. Dean about. That case is one we took over. He had applied for and been granted diversion. We received a diversion agreement from the county attorney's office in early March, sent that to the last known address, and we got that back in the mail. It was returned. And we haven't, Mr. Dean was going to do some extra digging to see if we could find a phone number, but we don't have any other information, not even an email address for him. So,
okay. Missy, is that the one Mr. Dean asked you about trying to locate some information on a while ago?
Yes, it is. And I've checked with the jail and he did not come in to be processed.
Okay. We'll deal with that case shortly with the rest of them then. Okay. Let's see. Missy, I just sent you a demand for jury trial. If you'll put them on our next available docket, our next jury trial docket. I trust they've sent that to the prosecutor. All right, let's see. We'll go on the record now. In the 13th Judicial District, the District Court of Greenwood, County, Kansas, this Friday, April 10 of 2026. Our first person, our 9 o'clock docket, the first section canceled for different reasons. So we're starting the second session, the 10 o'clock session of our docket with Courtney Allen will be on the record in 2026 TR 61. State of Kansas versus Courtney Juanita Nicole Allen. Please announce appearances.
State of Kansas appeared by and through Assistant County Attorney Paulie Dean.
Your Honor, Blake Cooper on behalf of the defendant, Courtney Allen. She appears in person by Zoom.
Announcements.
Your Honor, on Miss Allen, there's been an agreement reached. Sorry, back to her file. In that regard, Your Honor, Miss Allen does have a valid license at this time. We have verified insurance, therefore the state would be moving to miss count 1, no proof of insurance, but 4 proof, as well as count 3, speeding. In exchange for that, Your Honor, the state would move to amend the no driver's license charge to a no deal in possession, violation of 8-244. The agreed upon fine recommendation of the parties would be $100 if she doesn't have any history with that prior offense. Court costs of $108, a booking and processing fee of $45, as well as attorney fees if the court believes that that's appropriate after inquiry. The state would be recommending a 30-day controlling sentence suspended for 6 months of non-reporting probation, with the standard conditions of keeping the county attorney's office notified if they change address during that time period, pay and appear as directed, and no new law violations.
That is your agreement, Mr. Cooper?
It is, Your Honor.
Ms. Allen, that is your agreement?
Yes.
So to count 1, driving without proof of liability insurance, I understand that is being dismissed, that you've provided proof. As to operating a motor vehicle without a valid license, I understand that is being amended to operating without a valid license in your possession pursuant to KSA 8244. How do you plead to that amended charge of driving without your license in possession?
No contest.
By pleading no contest, you're not admitting the amendment, but you're not going to deny it and want to take it to trial. Is that correct?
Yes.
Is anyone forcing you to do this or promising you something other than your plea agreement if you do this?
No.
And you understand if I accept your plea, you will be found guilty, unable to appeal your conviction for driving without your license in possession.
Yes.
All right. I accept the no contest plea as freely and voluntarily, knowingly entered. And Mr. Dean, I presume you have evidence that if this were to go to trial would support this plea and charge?
I do, and I'd also ask the defense, Mr. Cooper, would you also agree that if the evidence contained in the affidavit and narrative and the complaint in this matter were presented unrebutted, then it would create a factual basis for the court to accept the plea?
Yes.
And Your Honor, I just state that Deputy Clint Hansen of the Greenwood County Sheriff's Office was doing standard patrol back on the 5th day of February 2026 in Greenwood County, Kansas, when he made contact with the defendant. Stopped due to a speeding allegation of a speeding violation. Identified her to be a driver, or was unable to identify her to be a driver's license because she did not have one in her possession. And all the above occurred in Greenwood County, Kansas.
All right. I find not only the defendant has freely and voluntarily entered this plea, knowing what she's doing, but that the state has provided a factual basis to support it. Therefore, I do find the defendant guilty of amended count 2, violation of KSA 8244, and dismiss the remaining counts on motion of the state for plea agreement. I follow the plea agreement for your sentence, Miss Allen. That is a fine of $100, court costs of $108, $45 booking fee, 30-day suspended jail sentence, 6 months non-reporting probation, with the conditions that you violate no law, that you pay or appear at the date that I will give you shortly, and that you keep the county attorney and your attorney notified of any change in telephone number, email, address, basically contact information. Now, where do you work, Miss Allen?
I work at Pizza Hut.
And what do you make per month at Pizza Hut?
I just started this job. I don't know what it's going to be per month yet. I make $10 an hour.
Okay, and where did you work last?
Sonic.
Okay. I am going to waive your attorney fees, but you will have the $100 fine, 108 court cost, 45 booking fee. Did you go over and get your picture taken and your fingerprints taken and make a bond like you were told to do?
She had been in jail, Judge, the last time we were in court, so I'm sure they did all of that while she was in custody.
And I can verify that because I have a Kansas adult disposition report. So.
Very good. Okay. I believe that totals about $253. How much time do you need to pay that, Miss Allen?
A few. I don't have the right answer. I could definitely make payments. I can have it paid off within a few months. I'm also on a fine agreement to make payments to another place, and so that's why I say that.
Okay, if I give you 90 days, will that be enough? I can go 120 if you need that.
Let's do the 90.
All right, 90 days. And I'm going to set what's called a pay or appear date. If you don't have it paid in 90 days, then you'll need to be back here in court, and we're going to talk about your probation and your payments and so forth. But if you have it paid, you don't have to come see me again. So, Missy, what do you have for about a 90-day pay or appear?
How about July 17th at 11?
There you go. July 17th at 11 o'clock. If you have it paid by then, you don't have to come back. But if you don't have it paid by then, or if you violate any new laws, I'm going to have you come back too. But if you don't violate any new laws and you have it paid by July 17th at 11, you don't have to come back. Do you understand that?
Okay.
Or you have any questions about that?
No.
You pay to the clerk of the district court. And I would suggest when you pay, you send a proof to your attorney, a copy of the receipt they'll give you, so he can put that in his file. And is there anything else from either party?
No, I was just going to go over it. Blake, I don't know that you've been having any issues the way I do these journal entries on the plea and sentencing. Obviously, we just got the case caption, transaction code on that adult disposition. Date we're here, you're appointed, no contest, stipulate to the factual basis. Dismiss count 1 with proof, verified proof by our office. Count 3 is dismissed per plea. Count 2 is amended to no deal position, 8-2-44. 30-day controlling sentence on count 2. Suspended for payment of fines within 90 days. 6 months non-reporting probation, 108 court costs, $45 booking and processing fee, attorney fees waived. Count 2, $100 fine is assessed. Conditions of probation, pay or appear within 90, or pay all fines and costs within 90, pay or appear on this date at 11 a.m., which is July 17, 2026. Back page is Tepe County Attorney's Office notified of whereabouts and contact, as well as no new law violations.
I approve.
Excellent.
Okay, and then Miss Allen, just on a final note, because every now and then, even though I go through everything and Mr. Dean goes over it again with the journal entry, I'll get someone in here on a probation violation that claims they never knew they were on probation. So I don't think you're that person, but just for good measure, you will be on probation from today for 6 months. And condition 1, don't violate any laws for the next 6 months of any kind. Condition 2, pay or appear by that date that's in your journal entry that we've gone over, July 17th at 11, and keep the county attorney and your attorney informed if you change your contact information. Do you have any questions for me about that?
No, ma'am.
All right. You don't have to see a probation officer, but you are on probation for 6 months. All right. Any other questions you have, you can contact your attorney. Otherwise, you can go at this time as you are excused from this hearing. It is concluded. Thank you, Ms. Allen.
Look, oh, he's already out there.
Mr. Cooper, are you ready on, by chance, Armstrong?
Armstrong, we're still waiting on some information. We are ready to go.
Actually, we can go ahead and take that up.
Okay.
Your Honor, I believe we have.
Hang on, let me announce his case number. We're on the record in GW 2025 TR 584, State of Kansas versus Justin Lee Armstrong. Please announce appearances.
Your Honor, State of Kansas appears by and through Assistant County Attorney.
Blake Cooper on behalf of the defendant Justin Armstrong, who appears in person by Zoom.
Your Honor, at this time, we do have, I believe, a plea worked out. However, the state is not in a position where it can proceed with that. We anticipate dismissing count 1 with verified proof of insurance. This is a situation where Mr. Armstrong was operating a vehicle that was not his personal vehicle. Therefore, the insurance company, which is the general, has been reluctant to share information without the policy owner's permission. It's my understanding the policy owner has given that permission, but in speaking with Jessica and Arlene, they indicate that they don't believe it'll be a fast process, even with that having been done. That at times they almost want a 3-way call. So I'm also going to propose to Mr. Cooper that if you could contact the owner and just see if he could just, because I know they send out these letters at owner's request, if they could just send a letter giving us the status of that policy for the date and time in question, that may be the easiest way to do it.
Sure.
That's what I was advised. They're like,
does that make sense, Justin?
Call, but they're like, they may, somebody's like, we don't see it noted anywhere in the system, and they'll try, but.
Right. No, I definitely understand. Like I said, it was my cousin, so I can definitely get that taken care of, whatever we need to do. Like I said, I know
get a letter from the provider that says the insurance was good that date of the ticket. And that date is, again,
is November.
The stop was on November 13th.
November 13th. Just make sure that they'll write me a letter or write you a letter that you can get to me. November 13th, it was good. Okay.
And you might want to make a note of the time, because I've seen people go out and get insurance after the ticket and say, I had it on this day.
I got it. I know I got it about 8:30 in the morning. That's how I started my morning off.
It was 8:47 a.m.
Yeah. That's what I was going to say. It was first thing in the morning. I was hauling equipment.
Oh, I see. Okay.
It was first thing.
So, yeah. And they could also, and sometimes they do this, you can just tell them to provide it to Greenwood County Attorney's Office, but one way or another, that would probably be the cleanest.
Okay. Good idea, Paul.
Just because people can create things a lot easier today, especially
right, definitely,
and everything else in the world. That's why. Otherwise, we just take the card and say the emailed card and say, all right, you got insurance. We verified it.
Right.
All right.
World's a lot easier to commit fraud. Just bluntly.
Yeah.
Do you think, would May 8th give us enough time, you think?
No. Plus that, Your Honor, that May 8th date, I've talked to Missy about this. I got a conflict I didn't realize I was competing with on that date. So, our current settings, I think we're good with, but I'd suggest that we move this to that first date in June, which I think is around the 8th. Well, Missy, what was that first date in June we were discussing?
June 5th.
June 5th. Okay.
All right. June 5th. At what time do you want him to come back? If 11, 10? Okay. All right, Mr. Armstrong, this is continued at your request to June 5th, 10 a.m. You must be back here at that date and time. And that will be added to the existing conditions, which will continue on that $2,500 surety bond you posted December 24th. Okay, if there's nothing further, we'll be in recess on Armstrong, or did you want to go over the journal entry, Mr. Dean, in any way?
Now, Blake, you good? But I mean, we'll
just continue. Just be back on June 5th, but give me that letter well in advance, Justin. Thank you.
Yes, sir. I'll be working on it today.
Thank you, Mr. Armstrong. You are excused from today's hearing as we will be in recess on it. And
Judge, we're ready to go on Albert Williams as well.
Okay. We are on the record in GW 2025 TR 594, State of Kansas versus Albert Dion Williams. Please announce the answers.
Your Honor, the State of Kansas appears by and through Assistant County Attorney Paul Eady.
Blake Cooper on behalf of the defendant Albert Williams. He appears in person by Zoom.
Okay, and announcements? Announcements.
I'll let Mr. Dean announce.
Okay, let me get the minute. All right, Your Honor, in regards to Mr. Williams, We have verified insurance was valid at the time and he's renewed his tag. Therefore, the state will recommend for a plea to the basically expired tag for a plea of no contest or guilty to that charge, whatever his preference, that he be assessed a $50 fine, a 15-day controlling sentence. Given the nature of the offense, I'm not requesting a probation time period. He would just be subject to contempt of court proceedings if he didn't comply, or potential suspension of license for failing to comply with the payments. And that we set this over for, and maybe assess court costs, booking processing fee, court can inquire as to attorney fees, and the matter be set over for a pay or appear.
Right, let me see if I understand that. No jail sentence recommended.
No, 15-day controlling sentence.
Oh, 15,
Just no because,
probation.
Right, because it's just expired tag and he's renewed it, $50 fine with those costs. I'm not asking for the 6-month non-reporting, just a pay or appear, and he can be subject to suspension if he doesn't comply. And the 15-day jail.
Okay, and no fine, but 108 court costs, 45 booking, and then
$50 fine.
Oh, a $50 fine. Okay. All right. Anything further, Mr. Cooper?
Your Honor, we're going to be asking you to waive attorney's fees as well. Mr. Williams has come up with a lot of money recently to register his vehicle and get everything in compliance. And he's going to have a hard enough time paying those other fees. And so we're going to be asking for 120 days to pay and the attorney's fees be waived.
Very well. All right. So, Mr. Williams, as I understand it, count 2, the insurance is being dismissed. So how do you plead to count 1, driving with unlawful registration or expired tag?
Guilty.
And by pleading guilty, you're admitting that you were driving on November 13th, 2025 in Butler County with an expired or tag or unregistered vehicle?
Yeah.
Which was it? Just your tag had expired or you hadn't had a chance to register it?
Yes.
Which one?
I haven't had time to
You
register.
didn't have time to register it, so it was unregistered. Okay. And of course, it wouldn't have had a tag if it wasn't registered. And this driving was on a highway in Butler County?
Greenwood, Your Honor.
Greenwood County.
Greenwood? You know which highway in Greenwood you were?
Judge, we would acknowledge a factual basis here.
All right. Okay, well, I will. Is anyone making you enter this plea today, Mr. Williams?
No.
You understand you're giving up your right to a trial and will be convicted?
Yeah.
All right. Then I accept your guilty plea as knowingly and voluntarily entered. I find you guilty of count 1, unlawful registration or expired tag, and dismiss count 2, the insurance for plea agreement on motion of the state. You will have a $50 fine, $108 in court costs, $45 in booking fee, but I will waive the attorney fees of $250. And I will give you 120 days to pay. Now, if you have that paid within 120 days, you won't have to see me again, but Missy wins his pay or appear.
It will be August 14th at 11.
August 14th, did you say?
Yes.
So you must be back here August 14th at 11 if you have not paid. If you've paid your money to the clerk of the district court or online or paid it in any other way authorized, then you won't have to be back. If you're not paid, you have to be back here August 14th, and we'll discuss why you haven't paid and whether or not your jail sentence of 15 days will apply. Any questions about that, sir?
No.
Okay, now, again, contact the clerk of the district court so she can tell you how the different ways to pay it, whether to mail it in, pay in person, or use online.
Okay.
Okay. All right. Anything further, Mr. Cooper?
No, Your Honor.
Mr. Dean?
No, Your Honor.
Very well. Mr. Williams, you're excused from today's hearings as we'll be in recess. You may go. And then that brings us to Mr. Irving. We will be on the record in GW 2025 TR 639, State of Kansas versus Jonathan T. Irving. Please announce appearances.
State of Kansas, by his true Assistant County Attorney Paul Dean.
Here, Blake Cooper on behalf of Jonathan Irving, the defendant in this matter. Mr. Irving does not appear.
Mr. Dean?
Missy, were you able to get any of that information from the jail to determine whether or not that he had been booked and processed?
I did call them and he has not showed up to be booked and processed.
Your Honor, this is a situation where the court had previously ordered Mr. Irving to be booked and processed to post an OR bond. That's not occurred. Mr. Irving has been, he currently did, I'll make sure I've got the correct reference here. He did apply. It did take the time to apply for and was approved for a diversion, which has been provided to Mr. Cooper, but apparently Mr. Irving has not kept everybody advised of his current address. So a little bit at a loss what to do with him. Wasn't no proof of insurance case. Looks like he's got a valid driver's license and no prior history. But I'm afraid under the circumstances, I don't know what else to do besides issue request of issue.
Anything further, Mr. Cooper?
Well, Your Honor, I would just, for the record, request a continuance. I understand the practicality in these matters. What I would say, Judge, is this is a case I took over from Mr. Paw. He had already applied for and been approved for diversion basically by the time I got involved. We did receive a copy of the diversion agreement from the county attorney's office sometime in early March. And we sent that out to the last known address we had for Mr. Irving, which is in Wichita. And it was returned to us on March 10 as undeliverable. I don't have an email address for him. I don't have a mailing address. I don't have a phone number. And I wish I did, because as Mr. Dean, acknowledged, he's gone through some, he's jumped through some hoops here. So it's a little inexplicable, but that would be my request, Judge.
Bond forfeiture ordered, bench warrant ordered, new bond $500 cash required.
Your Honor, I'm going to ask that we make that $758 cash.
All right, $758 cash it will be.
I will take care of the diversion for you, Mr. Cooper.
Okay. Sounds good.
Which reminds me, I want to go back to one of our gentlemen that we've excused and bring up a point. Which one was that? Was it Williams? One of them had a cash bond. And Chief
That was
Judge,
Williams, I believe.
It was, you're right. Chief Judge Ricky has ordered that cash bonds automatically go towards payment of cost and then refund to the defendant, which would basically negate the need for a pay or a peer. If you could talk to your client, Mr. Cooper, and let him know that, or send him a note that Judge Ricky has ordered that in all cash bonds, the payments come first. So we'll just take that out of the cash bond, Mr. Dean.
Okay, I guess
I used to
Cooper's
ask.
client doesn't even recall that, or he might have said, take the cash bond and give me a refund and I'll be done with you guys.
Yeah, I didn't. It didn't even occur to me, and he didn't mention it. So I'm sorry about that. I wish.
Well, I heard the ding and I checked it, and then I forgot about it as the hearing went on, and then it came back to me in this case that he had posted that. I used to ask the defendants, is that okay with you? But Judge Ricky has just made a local rule that they don't have any say in it, as I understand it. As I understand it, I may be mistaken, but that's
okay. I will have. We will get a hold of him right away and let him know that that's what's getting. That'll probably be a relief to him, frankly.
Yeah. Sounds like a good policy to me, or at least helps clear up some stuff on our docket at times.
Yeah.
And on the defendants too. So it seems to work out good for everyone. All right. Thank you, folks. I believe that's the last one, isn't it, Missy, on the docket?
That's all I have.
Judge, I need to double check. I take it Mr. Brewer apparently already paid and he's been already removed.
Rochelle, I think that was Rochelle Brewer, maybe. Is that right?
I showed Ronnie Brewer for.
Ronnie Rochelle. Okay. Ronnie Rochelle says canceled, but yeah, if you want to check that, go ahead.
And then
They took diversion.
Juliana Euler. Oh, I think Eller. That diversion's already been filed, I believe. Is that what you're showing on Eller? Juliana Eller.
Yes.
Okay. All right.
Okay.
Record completion date or time this morning.
Yes. Thank you both.
Have a good weekend, everybody.
You too.
Be safe.
Both of you. Thank you. We are adjourned.
Right. What are we doing?
Your Honor, I did explain to her that after our conference, that yes, if she does take the deferred sentencing, she can appear. I mean, she can report by Zoom, or by email. Sorry. I also explained to her she was concerned about having to do drug testing and alcohol testing. I told her that's not likely in a case like this. She's not been testing all along, so there's no reason to expect that. And that most likely in a case like this, you would give her a 6 month, although there's no guarantee of that. You would most likely give her a 6 month. And based upon that, she indicated she will accept the offer.
All right. Go ahead or sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Shanti Lingard.
Ma'am, you're going to plead no contest to the charge of retail fraud in the third degree. Is that correct?
Correct.
It's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would be the maximum fine. You understand that?
Yes.
I'm sorry, Your Honor. I thought you said guilty, plea no contest.
I should have said no contest. That's what I meant. Okay. All right. You understand you're pleading no contest, man.
Yes.
You understand what a no contest plea is?
Yes.
You understand that with a no contest plea, it means that you're not desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
Basis for the no contest plea, Mr. Cole.
Civil liability, Your Honor.
Ma'am, to that charge, how do you plead?
No contest.
You understand by pleading no contest, you will not have a trial of any kind. You've signed and gone through an advice and rights form. Is that correct?
Right.
Any questions about any of those rights?
No.
On the podium, please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been said today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're indeed guilty of this offense?
Yes.
Well,
I mean,
No contest.
don't answer that. That was my problem. Court has been provided Pittsfield Township Police Report for their case number 25562. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's sufficient basis in which the court could determine the defendant's guilt of this offense to dismiss count 1. Ma'am, I do have to advise you that if you commit misconduct as defined in Michigan court rules between the time I accept your plea and the time of sentencing, the court that you would not be permitted to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes. Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Defendants referred to probation for a pre-sentence investigation and report and consideration of deferred sentencing. Sentencing in this matter will be
May 13th at 9 a.m.
May 13th, 2026, 9 a.m. Bond with its conditions will continue. Ma'am, on your way out, stop by my probation department on the way down so we can start the process.
Okay.
All right.
Okay, thank you, Your Honor.
Thank you, Mr. Gold. Okay. Court calls case, People versus Kayla Walden.
Good afternoon, Your Honor. Raymond spoke for the people.
Ron Brown appearing on behalf of Kayla Walden.
She here?
Nobody's answering.
Your Honor, this is another situation. In full candor to the court, the people were unable to proceed today. I leave it to the court's discretion if the court wishes to proceed.
People being unable to proceed. Thank you, Mr. Cook. You're moving to dismiss.
Move to dismiss.
This case is dismissed. That's without.
Thank you.
Court calls case, People versus Angela Stoker.
Good afternoon, Your Honor. Raymond spoke for the people.
Ron Brown appearing on behalf of Ms. Stoker.
Your name?
Angela Stoker.
All right, where are we on this?
Formerly, or she previously waived jury.
Correct. And so we don't have a resolution today.
No.
Set it for today. So we already have a non-jury time. Well, I put the 29th.
That would be the Wednesday trial date.
Right.
That's correct.
Is that the date we set? All right. So this matter will continue to non-jury trial on the 29th at 9 a.m.
Thank you.
Okay. Thank you.
Thank you.
Thank you, Ms. Stoker.
Thanks.
Court does call the case People versus Kawandake Thomas.
Good afternoon, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Ms. Thomas. No, nobody answers, but Your Honor, from Community Corrections, we've received a completion of treatment from the supervising agent. So I don't know if she's in aftercare. I've called the number in the file.
Well, I don't know. I got the documentation, but I don't know that excuses her non-appearance.
Your Honor, rather than issuing a bench warrant, could we put it over for a week so I can find her?
Well, I can't because I don't have jury selection.
Well, I don't think we're going to jury selection because the prosecutor and I are aware of a pending felony matter where we're trying to create a global resolution to encompass this case or include this case.
What, another felony?
She, I believe, has a couple other pending felony matters up in circuit currently. Can pull an odyssey to see when those next dates are. I don't know that off the top of my head, but if I can just 1 second.
I think I got 1, 2, 3, 4 felony cases. Here's what I'll do. You think you're going to be solved with everything within a week?
I got to find her.
Yeah, I know. But what I'm going to do is I'm going to issue a bench warrant. I will not for a failure to appear at these proceedings, because I just don't know where she is. And I'm not aware whether circuit court does either. Set the bond at a $10,000 cash surety, but I won't have the warrant issue until the 17th.
Thank you.
Thank you. Is that it for my morning? And then for a lieutenant. Thanks, guys.
Thank you.
Thank you, Your Honor.
Court standing recess. All rise.
Thank you. Hopefully. Ready to see.
That's inaccurate.
This is my lieutenant of someone, please. You are in public trouble.
That is the kind of thing she could run to the DA's office and say, look, he texted me, even though your text was like, hey, you need to leave me alone. If she's reaching out to you, you just let Ms. Rios know that. She'll let the prosecutor know, and they can say, we need to change the conditions of probation. If you, Ms. Merritt, want to reach out to Mr. Gatlin, then you ask for no contact. I'm assuming she's not going to reach out to you. More importantly, you don't reach out to her. All right. You'll need to complete the family violence intervention program. You need to enroll in that within the first 2 months of probation. It's more than one class, and it takes a little while, so I don't want you waiting until the end. And you'll need to complete 40 hours of community service. Those you'll need to complete in the first 6 months of your probation. And if Ms. Rios, you want to reach out to me after Mr. Gatlin has completed the family violence intervention program and there's proof that he completed it, then I'm happy to get a report from probation to see how he has been doing. And then we could discuss an early termination. But for now, it's going to be the full 12 months. If you take care of the things you need to and get a good report from probation, then I will take under advisement early termination. Okay? 2 more things. One, you need to fill out a sheet that has all your contact information. That's how probation is going to get in touch with you. Okay. And they'll give you directions on where to report. Mostly it'll just probably be telephone reporting, but you may need to go there in person once. That's how they reach you. Don't miss that first appointment.
Yes, sir.
Number 2, there's an active warrant for you. So you actually have to go into custody now. You have a bench warrant at a state court for family violence battery. We verified the warrant, and I can't make another judge's warrant go away, but Judge Edie from state court signed a bench warrant for you.
For where? When? What? Oh.
I'll pull up what I can pull up, but you got to fill out that form. And then one of Ms. Rios's colleagues will step in to figure out more about that.
I figure out who your attorney is and send him an email.
So,
because he has no control.
it was issued in August of last year. So what that says to me is that you were supposed to be in front of Judge Edie in August of last year, and you weren't there. But I'm not the one to say I was there or I couldn't be there. I was somewhere else. I'm just letting you know some context for it.
Oh, man.
I'm going to email my colleagues to make sure you're not forgotten this stuff.
And I can't get out today.
I don't know how state court works, of how fast that goes, but I will reach out to them and let them know that you're there so we can, no one forgets about you. I'll send an email today. Did you know you had a case?
No, didn't know nothing. Then my girlfriend is out there. You could tell her.
That was the okay. Where'd you go for?
She's outside on the bench. And Judge, you said that was when?
I'm printing it out so you can have it. But Judge Edie signed it on August 12th of last year. And it sounds like you were supposed to be in his courtroom on August 11th. Because the warrant he signed said that Mr. Gatlin failed to appear. The state asked for a bench warrant and he signed it. So I'll make sure the deputies give that to you. So you've got that as a reference when you want to talk to your lawyer, say, this is why you're in custody.
But I just had court here. And if I had a warrant, I would have went to jail the last time I was just here, right?
We may not have known about it, but I'll make sure they get it. Yeah, oh, just so, any reason he shouldn't have it, that's the bench warrant, just so he can know what the situation is. All right, Ms. Rios, I know you've got some people to talk to. If I turn to Mr. Patterson and his client, is this a good time for you to talk with your clients?
Yes, it is, Your Honor.
Let's do that then. So Mr. Turner, come on up to the podium, please, with Mr. Patterson.
Good morning, Judge.
Good morning. Good to see you.
Thank you for allowing me to go to that bond here.
Hey, we took care of business and you guys are here still this morning. So we are on schedule. So we'll start informally with this. The concern, Mr. Turner, that brings us all together is that you've got a bond with some real serious charges. And it's a big bond. You got an ankle monitor and you told me, your lawyer told me, we're going to comply with all the conditions. And I got a report that a couple weeks ago, you were in places you weren't supposed to be. And you were in Union City and you're supposed to stay out of Fulton County with a few exceptions. Obviously you're in Fulton County right now and that's okay. Visiting your lawyer is okay. If your arm got busted and you had to go to Grady, not an issue. But hey, I'm gonna kick it with some friends on Jonesboro Road, not okay. So share with me what was going on.
Absolutely, Your Honor. My client, Forster, he works for Uber. And at the time on March 20th, at the time between 1:54 and 2:23 p.m., he was working for Uber Eats and picked up, Instacart. He picked up 3 orders at Kroger, and that was the location on Jonesboro Road. And that's the reason why I guess he apparently didn't realize that was Fulton County, but he was actually working for Instacart. And it shows he picked up 3 orders on Jonesboro Road in Union City at that particular time during that short period of time.
Okay. Got it. Yep. I guess that's a mall there.
That is correct.
It pulls up a UPS store and a Kroger. So I guess you just need to be careful about, it's going to make being an Instacart guy complicated. But certainly if it is Union City, East Point, South Fulton, those are all in Fulton County. Where do you stay?
Hampton, Georgia.
Okay, so you are in Clayton County?
Yes, sir.
Got it. Basically, if you are going past the airport, meaning north of the airport, you're getting into Fulton. The airport itself is in Clayton County. Now, if your line of work means that you need to be in Fulton County as an Instacart guy, you need to talk with Mr. Patterson, and he can talk with Ms. Smith, the prosecutor. And it may be that the state is comfortable amending the bond conditions to say, as long as it's between 8 a.m. and 8 p.m. and it's for work, that kind of thing, maybe they'd be okay with that. But the judge who issued the bond said you got to be out of Fulton County except for these few emergencies. Not work, but lawyer, court, and going to Grady. This isn't that. So you either need to not do Instacart, kind of inside the perimeter, although there's some of Fulton County that's outside the perimeter, or you and Mr. Patterson need to talk and come up with a proposal that he would make to the prosecutor saying, how about not on weekends and only during daylight hours, 7 a.m., 7 p.m. It's okay if Mr. Turner's in Fulton County. And the ankle monitoring company, it's all an algorithm. And so if the state says that's not an issue, then I'd modify the bond and say, as long as it's between 7 a.m. and 7 p.m., it's okay if the monitor hits in Fulton County. But if you're there at 3 a.m. on Jonesboro, we have a different situation. So
I will certainly get with the state on that, Judge.
Between now and then, you can't do it. So if you get that Instacart call saying, go to the Kroger in Union City, in Fairburn, in East Point, those are College Park. That's all Fulton County. Don't go there. Okay? I know you're not doing this stuff intentionally, but I can understand why the state would be concerned and why the person who's alleged to be the victim in this case would be concerned that you're showing up in Fulton County. The reason to keep you out was to keep the person who's named as the victim in this case feeling a little more peaceful about the fact that you have a bond at all, because that person didn't want you to have a bond. But the judge decided, given your background and representations your lawyer made, that it was safe-ish to risk giving you a bond. You need to not mess it up by doing something like this again. Okay? Any questions? I don't want you to leave here saying, I didn't understand what the judge was saying. I'm confused.
In other words, you need to check your app to make sure you're not going to Fulton County until I get with the prosecutor to try to get it amended. Okay. Okay.
All right. You're smiling. That tells me maybe.
No, I had a question.
What's your question?
So, that's kind of my way of making money. Like, our side don't really have too many orders going on. So be on that side.
Yep. So that's a reason for Mr. Patterson to start lobbying on your behalf to say, hey, is it okay if during certain hours, Mr. Turner is in Fulton County because it's for work? And it doesn't make a whole lot of sense to put you on bond and then say you cannot work. Just sitting at home isn't a productive use of your time. But if the state ends up saying no, it means you got to find a different gig. That you can't do Instacart that brings you into Fulton County. There are lots of jobs out there. This is one of them, and it works for you. And it'd be ideal if you could keep it, but you have some constraints. Yes, sir.
Before you try to follow up the real, this first original bond was issued by a second-year judge that stated that he could go work in school in Fulton County. And I thought that would transfer over to the modified bond. But that was the condition before, so that's the reason why I encouraged him to work and he couldn't find a regular job, so I encouraged him to do something to get some money to pay for his ankle monitor, which has been modified for the state because it was really supposed to be for the state in the first place. But the original bond stated that because when he was picked up in school in Fulton County. And at that time, the lawyer that was there representing him stated that he needed to go to school. So that's the reason why he allowed Fulton County work and school in Fulton County.
Apparently that bond was modified maybe at a bond hearing or something.
So I'm looking, I would have been the one who modified it at your request because having to pay for the ankle monitor was breaking the bank.
Correct.
I remember now. So it was a senior judge who was filling in for me, and Mr. Fortune was here for you. And it's a funny bond order, just in the sense of the format. It's not on our usual bond form, and it. No, it does not say what Dad says. It says that he shall stay entirely out of the Atlanta Judicial Circuit, which is Fulton County. They're one and the same, except lawyer, doctor, church, school, not work. So it did not include work. I'm not saying we can't change it, but that's just you're misremembering what it said. But that bond order didn't include work, and you had the curfew of 9 p.m. to 7 a.m. But you were paying for the ankle monitor. We then had a conversation, and I modified it on March 9th. Back on the normal bond form. And it says you're going to stay out of Fulton County. I just copied the language, except for lawyer, doctor, church, or school. Same curfew. And then you have to reside at Guelph Circle. Is that your dad's place? So you're staying where you need to stay. I don't mind adding work, but I want the state to talk with the victim and weigh in as well. And they didn't know today that they needed to do it. So I'm going to have Mr. Patterson work with Ms. Smith. She can do some outreach, and then we'll just do this via email. We don't need to get everyone back in court. But know this, Mr. Turner, unless and until the bond is modified, you got to say no to the Instacart routes that pull you into Fulton County. Because that monitoring company, they're good. It's automated. They get it. They send it to me. I reach out to Mr. Patterson saying what's going on. And I'm not finding that you're willfully violating it. It's for a good reason that you were in Fulton, because you're trying to earn some money, but you can't do that until we change the bond. And I don't want to think about changing the bond until the state has a chance to think about it and talk to the named victim. Okay?
Okay.
All right. Ms. Smith, is that something you can start doing early next week? Since it's a civil trial calendar week, I'll be out of your business.
Yes.
All right. If you could shoot an email to me, Ms. Nelson, and Mr. Patterson when you've had a chance to do that. And Mr. Patterson, if we get to midweek and you haven't heard anything, just send an email to all of us. Yeah. That may remind Ms. Smith. She's got lots of things she's taking care of. Absolutely. Okay. So until you hear from your lawyer, he'll know once I say I'll change it. And what I'll do is I'll send an email saying, yes, I will change it. That email is enough for him to tell you, go ahead and work in Fulton County. You don't need to wait for the bond order to catch up, because if you get a exclusion zone violation after I sent that email, the bonding company hadn't learned yet, but I would have given the green light for it. Okay. Questions?
Hey, one more question.
Yeah.
Okay, so I got a job in my area now that is accepting me in, which is Walmart.
When you say in your area, meaning in Hampton?
Georgia.
Okay.
I wanted to get more hours, so I wanted to see if you can accept the fact that I can work longer than the time that I can work now.
What are the hours?
I go in at 2 and we got to leave at 7:30. And
but you'd like to stay later than 7:30?
Because the amount of money that I got to pay towards my fees is not adding up with my check.
When you say fees, tell me what you're talking about, because we're paying for the monitor now.
My bond and my lawyer.
Oh, those fees. Those are important fees, and you need to pay those. And it's a big old bond, and it's a fancy lawyer, so you do need to be earning. Same situation. I'm very open to modifying conditions of bond that are linked to school or employment. And that's a simpler one because you're not going into Fulton County. So I would think that Ms. Smith would be less concerned if the curfew shifted from 7 a.m. to, I'll make it up, 11 p.m. So that you could work later at Walmart, and then you're in Clayton County that whole time anyway. We might not need to modify the exclusion zone. Which would you do both? You would do Walmart and be doing the Instacart, or you just like to do Walmart only but work longer at Walmart?
Right now, I like to do both.
You'd like to make as much as you can. Okay. Talk with Mr. Patterson, get the specifics. What I don't want to say is, hey, he can stay out as late as he wants. You would need to say, my shift ends at time X. And if I leave Walmart at X, it takes me 30 minutes to get home. So we need to have the curfew 30 minutes after the end of your shift. Get that to Mr. Patterson. He will get it to Ms. Smith, and then we'll talk about it. I don't think any of that will require you to have to come back in here, but we'll see what the state decides its perspective is going to be.
Thank you.
You bet. And this is your last chance for questions. That's it.
Right. No, they're not going to do that.
Nah.
Okay. All right.
Thank you, Judge.
You're welcome.
And have a great day.
You too.
Judge,
Yes, ma'am.
really quick, Ms. Willingham went out to go call the victim from this case, to see if he would be opposed to that,
Oh, in Mr. Turner's case?
Yes.
Okay, well, here's Ms. Willingham.
I'm texting them now. They
Okay.
didn't answer, but they just text back.
Okay.
Either way, I'll just update people.
Yeah. He can.
I'm trying to get an answer before you.
No, I appreciate the real time thing, but this got dropped on you. I wasn't thinking, where's the answer from you all? I was trying to give you a few days next week to do it, and he can leave Walmart early until then. So if you get an answer while we're here, but let's just do it through the email.
Okay, I do have a question real quick, Judge. With cases like this, I didn't see anything in the, like anything filed telling me the reason that we had this, like income monitor issue. So is it something where if I see something like this on the calendar, it's always like some type of violation? Or do I just need to inquire on why it's on the calendar?
It would usually be a violation. The violation notices get sent to someone in court administration, and then that gets pushed out to the judge whose case it is. It also gets sent to about 5 people in the DA's office.
Okay.
So they probably get 1 million a day because there are a lot of ankle monitors out there. But really the way it was meant to be designed is that there's someone in your office who gets them and says, all right, Correll Turner, that's that case. Oh, that's Ms. Smith. And they get it to you. So you got notice when I got notice of what the violation is. Nothing wrong with reaching out to Ms. Nelson to say, hey, what's the issue? And she'll just forward you what I got, which is this automated report from A Second Chance that said, whatever those specifics were, this nice little box. It lists the conditions: stay out of the circuit except to do these things. And then here he is at 4550 Jonesboro Road between 1:16 p.m. and 2:35 p.m. And we think that's a violation. And it was. There was apparently a good explanation for it, at least this time. I was a little less spun up because it was in the middle of the day of a weekday. Like I said, if it had been 3 a.m. on a Saturday, that would have been more problematic for Mr. Turner. But that notice that I have in front of me gets sent to your office to, I think it's a generic email like ankle monitor violations, but it's monitored by 4 or 5 of the people in your office. And they just need to figure out if they're going to make the effort to push it out.
All right, thank you, Judge.
You bet. Did he have something in his pockets? He got really sweaty really quickly. Great. I was waiting for you to come out with like a gun and drugs because he was. Okay. So it was like instant sweat.
No, that's when you told me.
Yeah, no, I know. That's why I was wondering, because we've had it happen before where someone gets super agitated and no one wants to go into custody, but it's because basically now I have a whole new case because I had 18 bags of marijuana in my pocket. Usually it's not a gun because in theory they get stopped at the metal detector, but some stuff makes it through. And we've had amazing amounts of drugs show up.
She said she couldn't really help me. Okay.
Oh, this is what the case with Judge Edie is? Yeah, you recognize the names. Huh.
This is the.
Yeah.
Tuesday, I was I'm talking, so. Yeah. So, I guess it's all this turn forward, so I was turning to come in and take me. So by the time now I call the county, we looking for you.
He's gone.
Yeah. But the attorney was like, well, I'm obligated to tell this for you may go into custody. But I didn't know what the charge was. I didn't even charge them. Kidnapping, terrorism threats, and sexual battery. It is a non charge.
So I'll be engaging with those two judges, NC1 and NC2. It was brought to my attention by some of the sheriff's staff that the judge is letting the lawyers know, and then what you saw happens. And that's not how it needs to work, like what you just saw, and not the, hey, psst, because then people are going to disappear.
Because that's all we do, all, I didn't do it. Me and Pierce are doing it now. He always.
Yeah, so ideally someone lets the judge know in advance. Sometimes we don't figure it out. So I may get, like you heard Ms. Simpson say, hey, check your chat. And so we're a little discreet about it. And then one way we've dealt with it, and some judges do, is they say, hey, Mr. Gatlin, I need you to sit in the jury box. And so then you can't, right? But because you're there, and sometimes Ms. Simpson, I don't like doing that. So our deal is just, we know, but we don't talk about it until everything else is done. And say, hey, there's one more thing we need to talk about. And
I've been in the jury box for the day.
yeah, I can. I just soon you not have to be in that situation. And I'm fine with you sitting right there and Ms. Simpson sitting right there. Because as long as we don't bring it up, we're good. There were a couple others who were like, hey, what are we?
Hello.
All right. This is a dismissal.
It is, Your Honor.
Not quite a dismissal. Remember the answer.
Claiborne, stop. Go ahead, Ms. Kazar.
This is also the one where Ms. Claiborne had submitted a 504 request, and that has also been approved.
So her request was approved. All right, Ms. Claiborne, what's the issue?
The issue is that nobody has contacted me to let me know that it's approved. This is my first time hearing that.
Okay, now that you've heard it.
My question is when will it take place?
What's your question?
When will it take place?
Do we know?
I just received notification that it was approved. I think she should contact her property manager.
Okay, you have to contact the property manager to see when that will take place.
Okay.
But, and then the other thing is that the check was received, so she's at a zero balance, and then that process has been approved. Any other objection you'd have to the dismissal, Ms. Claiborne?
No, besides my other service requests, I just wanted to know when those will be done too as well. So I guess I need to contact the office. So in the case that they say if they don't do it within the next month or so, what would be my next step? Can I put my rent in escrow? What are the steps to that?
Ma'am, you can do what you wish to do. I can't advise you of that. He's at a zero balance. And then that process has been approved. Any other objection you'd have to the dismissal, Ms. Claiborne?
No, besides my other service requests, I just wanted to know when those will be done too as well. So I guess I need to contact the office. So in the case that they say if they don't do it within the next month or so, what would be my next step? Can I put my rent in escrow? What are the steps to that?
Ma'am, you can do what you wish to do. I can't advise you of that. All I know is that the issues that are before me at this point, all of them look resolved, and I can't. There's nothing for me to try. And they're seeking to dismiss the case. So
I understand that, sir. Your Honor, what I'm asking is how do I go about putting my rent in escrow if it's not completed? Because this is affecting
I'm gonna suggest that what you do is you contact an attorney as to how to do that. I can't give you legal advice. Okay?
Oh, okay. Thank you.
All right. Your case is dismissed.
Thanks.
Court calls case of Eladot Property Management versus Nicole Freeland
Very related.
and Aaron Gates. Freeland, Gates, they are not here. If you'd like to call, raise your right hand. Solemnly swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth, so help you God. Go ahead.
Non-payment of rent, the rent to retain possession is $1,156.83 for cost of $325 for new redemption, $1,481.83. Plaintiff is requested default judgment. Extra, the writ to issue after 10 days if the total amount remains unpaid, as well as a money judgment and amount. They were present.
They were present. Judgment to the plaintiff, that is by default for possession and money, redemption amount, and money judgment in the amount requested. Writ to issue in 10 days. Court calls the case of Evergreen Apartments versus Mia Garrison. Mia Garrison, no response, you may proceed.
Thank you, Your Honor. The rent to retain possession is $2,107.69 for a cost of $170. Redemption of $3,279.69. Plaintiff is requesting entry of a default judgment for possession only with a writ to issue after 10 days. The total amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested. The writ to issue in 10 days. Evergreen Apartment versus Dwayne Watson.
Marissa Gazari for plaintiff.
Good afternoon, Your Honor. I'm Dwayne Watson.
Good afternoon, sir. All right, where are we on his?
Your Honor, balance is $3,510. And that the HOC application was denied.
What I'm looking for on this sheet. Watch. Okay, client is the last you have that it was denied.
Yes, the note that I have from my client says that there wasn't sufficient income for their requirement.
Okay, when did you get that message? So this is where.
It's from my client. It just came through to news. I don't know when it was.
Got it, because the sheet they sent us says client is sending last check stub 49 for eligibility determination. Did you already do that, sir?
Yes, sir.
When did you do that?
Okay. The last time I was in court, I talked with the Hawk organization, talked with Alicia Sykes. That what the attorney said is correct, but things didn't change as of today. I talked with Hawk.
When did you last talk with Hawk?
Today. I talked with Miss Alicia Sykes. I also talked with Miss Sydney. I can't think of her last name.
What did they tell you?
Well, I've paid over $1,000 this month. So my remainder balance is $2,996 and some change. I talked with Alicia Sykes today. She said that everything what I did, if they approved of the grant to take care of the remainder balance. I also
What time was that conversation?
this was about I want to say about 9-10 o'clock this morning.
And you get a message saying he was denied sometime today.
I can message site, see.
Sure. All right. Why don't you have a seat?
Yes, sir. Thank you, Your Honor.
That's the problem with this paper thing that they have now, because things can change, and it was much better when we had Amy present. Well, I guess that's not up to me. Gulfside Lake, 1 and 2 versus Lakia Williams
Here.
and Coran Williams. Leah Williams, Ron Williams. Okay, have you received their check for 3,000?
So I have their balance as $1,660.
That be April?
Yeah, the $3,000 check came in on the 3rd of April. Or maybe it was the 2nd of April. And it was applied to the ledger. So yes, my balance
Is her April rent?
Yeah, all these.
Oh, boy. Okay, so here's part of the problem. Part of the problem is she's not here because she's always here. She's not here because she got her balance down to 3,000. They said they were going to pay it. She believes that she's clear. I'm sure of it.
My notes from the last hearing indicate that she was gonna pay April rent by the 3rd.
Oh, she was. That. Okay, I don't have that. Let's do this, because otherwise what's gonna happen if I don't think I could properly dismiss it. Let's try to give her another shot to come in, because since we're just dealing with April, because we were much further behind. Let me adjourn it out to the 17th. At 1 p.m. Let's see, and if she doesn't show up or doesn't pay, then I'll deal with it then. Gulfside Lake 1 and 2 versus Dewan Wintermate.
Carissa, what was the last name? Sorry, what was the last name?
Wintermate. That you may not think. I said this for a writ hearing. Oh, I do. It looks like they paid. That's why you may not have anything. And your office sent in a satisfaction.
Yeah.
So, case is satisfied. Gulfside Lake 1 and 2 versus Deion Brown. Sure.
Hello, Your Honor. Deion Brown.
Yes, sir. How are you?
Doing well.
All right. Let's see. Where is he now?
$1,006. I had a note from my client indicating there was that Mr. Watson had indicated there was amount in escrow.
Yes. So I have 620 in escrow.
Plaintiff would request that that would be released.
Yeah. And how much is your monthly rent?
$675.
Okay. So he paid this on that. Okay.
And then I made another payment on the 9th.
So you paid another payment on the 9th
Mhm.
to the landlord?
I did it online. It was for something. I'm not exactly the exact amount, but I emailed,
Hold on a second. You paid some 400 on the 9th yesterday?
yeah, I paid after the 620, whatever the remaining balance was, that's what was paid on the 9th.
Got it. I see what you're saying. So do you see that?
Yes, I see $445 paid, so it would leave the balance at 600.
665? Okay. So, and I have 620. So you're about 645, you said, so you're about $25 short.
So technically the late fee is being waived because I paid it before the 10th. I already talked to Melissa. She emailed me. I have the copy of the email. She said she would email the lawyer to let her know.
Okay. Here's what I'm gonna do. Okay. You got that in. So what I'm gonna do is release the 620 to the plaintiff. I'll adjourn this out 1 week, okay? And let them, because I'm talking about $25. So let that get settled. If it doesn't go that way, just pay the 25 if you got it, okay?
She told me that the funds had to be released from escrow first before she could remove the late fee.
All right. I'm releasing it today. I don't know when it'll get there. I'll adjourn it out to the 17th, 2026 at 1 p.m. Okay, so hopefully that check can get there. She waives that, then you're all set. Okay.
All right.
If you are, then yeah, I don't need to see you.
Okay.
Okay, but you might want to check before you don't show up.
If it's
Just check and make sure that you received the check.
okay, thank you.
Got it?
Got it.
All right, fella. Have a good weekend.
All right, have a good weekend.
Strong Future Homes versus Ashley Womack.
There for plaintiff, not sure.
Ashley Womack. Oh, there she is.
So, Your Honor,
Hello.
Ashley Bowman.
All right. She just had, well, what do you have as her balance?
I have $2,272.28.
Okay, so she's under the 3. You had her intake appointment with Hawk on the 7th.
Yes, they told me that all I had to do was bring in or send in the paperwork. The only reason I haven't done that yet is because I received the paper yesterday. Do I owe like a security deposit?
Pardon?
I received like the paper from the courts and it says I have a $300 security deposit too. So that's why I haven't turned that in.
300 free deposit?
Yeah. Which is really weird because I've lived there for like 6 years. I don't know why I have another security deposit.
Hold on a second.
It was like 300.
Pardon?
Ledger.
Yeah, and I don't see anything on the complaint.
Is there a way to get a paper from here that shows how much so I could send it into Alicia? Because that's the only issue is that the paper I have says I owe $353 security deposit.
I don't know where that paper is coming from, ma'am. Only, and the reason I say that is I'm looking at a copy of the complaint and it doesn't say anything about a security deposit.
That's really weird. Because the first paper I got, it didn't have it had like 1 cent is what I owed on security deposit. And then the paper I got just yesterday said.
Is that coming from the landlord or is it coming from?
I think the landlord.
Okay, so I don't know anything about this.
Okay.
Okay, so what they want you to turn in is the complaint that you received.
Okay.
I think that's the paperwork that Hawk is looking for.
Yeah, they said from the courts of what I owed, so.
Yes, so they're gonna want a copy of the complaint. You would have gotten one by mail. You would have gotten two by mail, and then one would have been delivered to you somehow.
Okay, I got them all at once, actually.
Yeah, okay.
So that's,
What I'm gonna suggest you do is get that paperwork, get clear with Hawk what they want. But I think they want your complaint.
okay,
And they're gonna want a ledger or some type that either they'll get from the landlord or from you. So
okay,
you might, what I'm gonna suggest you do is go down to your landlord, get a copy of your current ledger and your paperwork that from the court and get that to them.
okay. You should-
Okay?
That show issued a check, so that's all.
Right, I'm sure that's what they're looking for. They're just looking for that current balance. So let me adjourn this out to the 17th, 2026 at 1 PM.
Thank you.
And let's see where we are, but make sure to get that paperwork down to them, okay?
Thank you.
All right. Thank you.
Good night.
Then I have Evergreen versus Figueroa. That's dismissed on plaintiff's. And do we? Watson, did more time on that?
Oh, I'm sorry. I'm just waiting. I just sent the email, so.
Got it. Okay.
Your Honor,
He looks comfortable saying word. Yeah, go ahead. Wait.
I'm sorry, I didn't mean to interrupt. Is there anything I can prevent to expedite this case right here?
Well, no, I'm waiting. What you said, come on back up. Court calls the Watson. Go ahead, state your name again.
Dwayne Watson.
Okay, go ahead. What do we know?
It's like a zero for plaintiff. I just received an email from my client saying that there is an update from Hawk today. His application is now. So.
Okay, all right. Kind of what I have, well. Yeah, I get it. Don't worry about it. We got it solved. All right, so his application's approved. Which if they cover everything, what do you have as his current balance?
I have $3,510.09.
Okay, so what he's gonna need to get in is 510.
I took care, I didn't mean to interrupt. Go ahead, sir.
Oh, no, go ahead.
I took care of that today. I can show proof.
You just doing all kinds of stuff. So you paid the 510.
Yes, sir.
Got it. Which is probably why they approved it, because
Yes, sir.
they paid that. All right. So
Absolutely.
let me do this, Mr. Watson.
I have that now in new ledger as well. So
You have the 510. So he is at 3,000,
we got
a little under 3,000. They've approved him probably for the 3,000. Got it. Okay. So here's what I'm going to do. I'm going to adjourn it out 1 week. Let that check get through.
Yes, sir.
If they paid it, I don't need to see you.
Okay.
Okay. If they haven't, stop in, just try to make sure you're all clear.
Yes, sir.
Okay.
Yes, sir.
All right, Mr. Watson. You have a great weekend.
Hey, you as well. I appreciate you, sir.
All right.
Right on.
Thank you. All right. That's it for that, boss. All right. We're back on time again. Sure that will get all messed up because Mr. Hampton. All right.
I bit my tongue.
All right.
That hour block was done. I thought maybe you were on the 9 now. I wasn't sure.
Yeah, sometimes, you're right. Of course, station.
All rise. See,
Thanks.
I have no problem paying that. And make sure that she texts the company that did it and send certified mail as proof that they were asking for a warranty within the 1-year warranty period.
And did you have an opportunity to see whatever contract the management office had with the contractor who poured the cement in 2024?
She told me that he's not responding to any of their phone calls, and then I reminded her again to text him.
But did you see the contract to know if a warranty existed?
It's standard 1-year warranty in the state of Michigan for cement contractors.
And what's that applicable? Do you have, that statute?
No, I haven't had to think about that in 30 years. But I do know this. The reason why the warranty is that low, because we live in a state with a freeze-thaw cycle, and that greatly affects the subsoils underneath the concrete. It could heave the concrete up during the winter freeze, and it could lower it back down in the spring thaw. And it could also wash out the subsoils. That's why there's only a 1-year warranty with the vast majority of the contractors.
Thank you, Mr. White. You indicated that HUD housing has a standard of 3/4 inches. What is that standard?
HUD housing, VA, loans for housing, that there cannot be greater than 3/4 of an inch trip hazard, or you cannot get the loan to purchase the property.
Got it. Is your property, the site that you lease or the home that you own, involve HUD housing?
That's why I asked earlier if they had HUD housing here.
No, I'm asking you, sir. Does your site involve HUD housing?
I don't know. I don't own the property that this sits on.
To purchase your home, did you obtain a HUD loan?
No, I purchased a home and paid cash. And for a year or two, I actually used it as a field office where I had dual residency, one in Wyoming, a suburb of Grand Rapids, and then basically here. So whatever part of the state I was working more on, I had a place to stay at either way.
Understood. You indicated that you referenced they drove around on the golf cart and took pictures. Who is they?
The office employees, but they didn't state exactly which one it was. So
which office employees were they,
Lakefield.
Mr. White? I understand that, but
Lakefield.
who was on the golf cart?
I don't know. I wasn't there watching them.
So that's hearsay testimony. You heard from somebody else that they were at the property on a golf cart?
So somebody there in the office told me that they went by on a golf cart and said there was nothing wrong with my driveway, and they also relayed that to you.
When was this?
You have to understand, I'm recovering from a severe traffic crash. For the last 4 days, I haven't been able to get out of bed. So it's not like exactly like I have my secretary here taking notes for me.
I just have to strike that as ask the court to strike that as non-responsive. Okay.
So, just so that I'm clear, Mr. White, you didn't see the people on the golf cart. Someone told you that, correct?
Somebody up at the office, Your Honor.
That is hearsay. I will strike that.
Thank you, Your Honor. Mr. White, you
With respect to your use of the site and your care team's use of the site, would you state that your use is done with care?
I don't understand that question. Are you asking me, do I need caregivers?
No, sir. I'm asking, when you use the site, your use of the site, your treatment of the site, your care team's treatment of the site, the real property that your home sits on.
Yes.
Is there care taken, or would you say you and your team are negligent or reckless in your use of the site?
Nobody that comes here is negligent or abusive of any part of this property, both the outside, which Lakeview owns, or the inside, which I own.
And so you would take the position that you adhere to the community rules and regulations with respect to your use of the site?
Unless there's a rule or regulation that I'm not aware of, I try my hardest. I never had a complaint by a single neighbor in 7 years living here. And this is the only issue I had with this park is under the current management of it now.
Okay. And so again, your position is that you've utilized the site in a manner consistent with the lease or the rules and regulations.
Yes.
I'd like to draw your attention to, bear with me one moment, Your Honor. I realize the screen sharing went down again, so this is Plaintiff's Exhibit 1, Your Honor. And Mr. White, and this is page 10 of that whole packet. This is the community rules and regulations, Your Honor. It says Lakeview MHC community rules and regulations. And I'm specifically drawing Mr. White's attention and the court's attention to this section regarding automobiles. Subsection A. Your Honor, ordinarily I would ask Mr. White to read it. I don't know if he's able to do so or if the court would just like me to read that into the record.
Are you sharing it again?
I thought I was screen sharing it. Hold on one second, Your Honor. I am now. There we go. Mr. White, are you able to see the section I'm referring to? I'm going to highlight it here. Do you see this section?
Yes.
Do you see subsection A here?
Yes.
Are you able to read that section?
Parking of vehicles is not allowed on vacant sites, fire lanes, lawns, or patios.
Have you adhered to that section? You and your guests, you and your visitors or care team, have you adhered to that
I
section?
have only one of 4 sites on my street that has a double wide driveway. So 2 cars can be parked side by side, but I put up a little guardrail along my patio because somebody struck it about 5 years ago. To make sure that didn't happen again, I gave up a parking spot and put up a guardrail system. So I can only get 3 cars.
Okay. So your testimony today is that you adhere to this section of the rules and regulations. Is that correct?
Yes, and every vehicle I ever parked that I owned was legally licensed and tagged at all times.
Your Honor, I'm going to offer this next photo for impeachment purposes only. This is not a document that was previously provided to the court, nor was it provided to Mr. White. Mr. White, is this your home here?
Yes, it is. And that car's tires are sitting on patio blocks that I widened the drive utilizing. So it's not on the grass. And if it was, it's from somebody coming to visit me because I have a dark charcoal gray Ford Fusion that was totaled out in a car crash back in December. And if I'm unaware of somebody parking wrong, it would be immediately addressed. But they are on patio blocks that line in between the grass and the driveway.
Mr. White, you understand that you're responsible for the behavior of your guests and your visitors?
Yes, and they are not parked on the lawn. They're parked on patio blocks that I installed instead of the dirt pothole that used to be there.
Okay. Your Honor, with respect to, let me pull up the ledger. And so, Mr. White, it was your testimony.
What time is it?
27, I gotta get going.
Oh, hold on.
Do you need a moment, Mr. White?
My last witness has to leave.
Your Honor, I don't have an objection to pausing my cross-examination if Mr. White wants to call his last witness.
All right, we'll let you call your last witness, Mr.
All
White.
right. Hey, Rebecca, can you come in here, please?
Yeah.
All right. Good. And Your Honor, it's showing me pictures of two little
Yep,
baby
I'm
kids.
turning that
Yeah.
off, Mr.
I don't
White.
have any children.
They're down now, sir.
Right. Go ahead, and they're gonna ask you to be sworn in.
All right, please raise your right hand and be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please state and spell your name for the record.
Rebecca Moore, REBECCAMOORE.
All right, thank you, Ms. Moore. You may question your witness, Mr. White.
Rebecca, is that your car that they just showed me a picture of, the silver Fusion?
I had a gold Fusion. I didn't have a silver one.
The
I didn't
picture
see
is
the
down.
picture, so I don't. I have
It
gold.
might have been my eyes, but whenever you parked where I used to park,
Mhm.
was that on the grass, on the driveway, or on patio blocks that were
I parked right on the
installed?
edge of your grass.
The patio blocks?
Yeah.
Okay, but not on the grass?
I don't park on the grass.
Please, everyone, please stop. Ma'am, you need to come closer to the screen so that we can pick up your testimony.
I'm sorry.
You're-
No, I don't park on the grass. I park next to the patio blocks. When I pull in, I usually back in right next to the patio blocks.
Miss Dornbush, could you please put the picture of the car back up that you just put on?
I can. Yes, Your Honor, give me
It
one
showed it
moment.
on the patio blocks, but is that your car that they're pulling up?
1 second, it's not up yet, Mr. White.
Oh.
Yeah, that's mine.
And are you on the patio blocks or are you on the
I'm on
grass?
the grass that time, yes. I am on the grass that time. I can say, yes, I am on the grass when I backed in.
Okay, and is that a common occurrence for you or is that like,
No, that was just an accident. Was just backing in.
okay.
Might have
So
been.
one-time occurrence?
Yeah.
And Your
Yes.
Honor,
I don't have that car no more.
You know, you could go down the streets here and see cars
Mr. White,
parked.
you can't, Mr. White, you
Okay,
can't
hold on.
testify right now.
Right. You see my name on the lawn.
Right, any other questions for this witness, Mr. White?
Yes, I do. Rebecca, have you ever seen cars fully parked on the lawns in this community?
Yes.
Thank you. Now, in regards to my care, you started taking care of me around August,
Beginning of September, yes.
somewhere in that period of last year? All right. And have you known about my longstanding dispute with the office in regards to my concrete?
Yes.
And during that time, did they repair the concrete?
No.
Now, sometimes you park on the other side of the driveway, is that correct?
Yes.
And where they pulled the forms out where the grass and dirt is a lot lower than the concrete.
Yeah, because I've almost fell.
You almost fell. Okay, and do you see that as a safety issue?
Well, yes, especially at night when I'm leaving. It's
Oh.
dark and I can't see.
And you could are you saying you could very easily trip, fall, and get hurt?
Yes.
No additional questions for this witness, Your Honor.
All right, questions? Ms. Dornbush.
I don't have any questions, Your Honor.
Thank you for allowing this witness also go out, because I'm pretty sure we all thought that we'd be back to our regular lives again.
Thank you. You are excused, ma'am. All right, we'll return to Mr. White's testimony. I believe you were asking questions.
I was, Your Honor, thank you. I believe where I left off, Your Honor, was, and bear with me a moment while I pull the document back up. And share. Okay. Mr. White, I believe your testimony was, and correct me if I am wrong, but your testimony was your belief that you had signed a lease agreement for the term of April 1st, 2025 through March 31st, 2026. Is that correct?
Yes, and it was turned into the office.
Who was it turned into?
I'm not sure of her name, but it wasn't Miss Green. So it was one of the secretary's staff there.
And who turned it into the office?
Back then, I was still able to get around pretty good on my own, and it was me.
And you handed it to this person directly?
Yes, as you come up to the little door, and it's a half door that had a ledge on it. As you look straight ahead, it was the person at that desk. I know Miss Green's office is around the corner to the right.
Do you recall what day you turned that in on, sir? Give or take. I know you may not remember the exact date.
No,
so
I cannot.
fault you for not.
I mean, it was over a year ago, and
Was it before or after the new lease term started?
I got it before the lease term started, and looked it over and then signed in the appropriate boxes. Then double checked to make sure I didn't miss a signature anywhere. Then took it up there and dropped it off.
And did you retain a copy for your records, sir?
No, because I don't have any copying equipment here. And my office is on the other side of the freeway, about 15 to 20 minutes away. I didn't have a chance to zip to my office and make copies of it.
Okay.
So I signed whatever copy they gave me, and that's the only copy that they gave me.
And your testimony was that the community was charging you late fees as a result of the month-to-month fee. Is that correct?
As a result of the month-to-month fee, they have charged me late fees on that.
I'm asking you, sir, is that your testimony? Is that they were charging you late fees?
I'm not sure, because keep in mind, I got thousands and thousands of dollars in different bank accounts. And a lot of times I get lazy and I just ask them, what do I owe you? And whatever they tell me, I wrote a check for.
So at that point, you were willing to accept whatever charges management told you was due and owing.
Or if I was legally entitled to pay it, I would have, of course. But not anything that wasn't my fault, which them losing the copy of my lease, in my opinion, is clearly not my fault.
Are you aware, and I'm going to refer to your ledger here, that in August of last year, management credited back several charges, late fees and whatnot on your account?
I wasn't aware of it, but if you're telling me they did it, I have no reason to dispute it.
And following that time frame, were your payments taking into account the month-to-month premium?
Almost every month, I called up to the office. I asked them, how much do I owe you? So I can make out the check.
And did you question any of those months what the balance consisted of?
Well, the reason I did that, to make it clear, is because our water and sewer bill varies differently each month. So I wanted to make sure that I was paying usually more than enough to cover what I owed and then have a credit.
But don't you receive that information mailed to you?
The water sewer comes on a postcard, okay? But sometimes when I'm shredding thousands of documents, that water sewer card might be in between them, and I shredded it.
I understand. Okay. Mr. White, with respect to the current lease renewal, you have elected, as you stated, not to sign it yet because you were worried about it affecting your legal rights. Is that correct?
Correct.
So you are agreeing that for the month of April, you are a month-to-month resident and that you will continue to be a month-to-month resident until either you elect to sign the lease agreement, or you would remain a month-to-month tenant if you don't. I mean, there's going to come a point where a decision is going to have to be made. Are you intending to sign the lease or not?
The lease that I signed and delivered to that office for the period of 2025 to 2026, that I was being overcharged $39 a month as a result of them losing that lease. Now, if it's something I did, I have no problem paying the late charge. And to give you an example of that, they had a not sufficient funds.
Mr. White. Sir,
Yes,
I'm gonna tell you what the law is on something so that you can understand it. You have a duty to mitigate your damages. Okay? What that means is, if they lost the lease and there was a new lease that you could sign, you can't wait until the end of the term and then argue that you should be refunded all the money because you should have just signed a new lease once you knew that it was lost. You have a duty to mitigate your own damages.
and again, Your Honor, I was unaware of that because I didn't go to law school.
I understand. But I'm telling you now.
Yes, ma'am. I mean, if you want, I'll sign the lease now and have someone take it up to the office.
Well, I can't give you legal advice. I can only tell you what the law is, and I'm telling you what the law is in the context of the statements you're making today. So you can be fully aware of what you're testifying to, as well as to the fact that what could happen in the future. I can't give you legal advice or tell you what to do about your lease.
Yes, ma'am.
And Your Honor, at this point, I don't have any further questions for Mr. White.
All right, Mr. White, is there anything else you would like to say based on the questions that you've been asked by her at this point?
If nobody drove by a golf cart and took pictures of my driveway, how did maintenance know they come by my driveway and inspect it?
Is that a question for somebody? Or is that, I'm not sure what you're trying to say right now. I mean, I know what you said. I'm just trying to figure out if you're making a statement. Are you making a statement?
No, that is a question. If nobody came by,
But no, you're the person on the stand, so you can't ask questions while you're on the stand. You can make statements.
okay, I'll make a statement. Since maintenance showed up here to inspect my driveway, that should be proof that somebody at a prior date was aware of the complaint, and it's just so frustrating that they'll sit there and take a picture on one day that a caregiver came in here and parked that was maybe 6 inches on the grass, when there's entire vehicles parked on the lawns in this park on a daily basis. And I was just wondering why they didn't provide all them pictures of them other cars. That the entire car was parked on the grass. But so Your Honor, I have the check here for $800 for this month's rent. I know there's going to be justifiable late charge on that because I wasn't aware that my care staff didn't take it up to the office. I have no problem paying that. And earlier, I had a money transfer from one bank to another so I can pay my rent and bills with that. And it didn't go through on time and it bounced the rent check. I have no problem paying not sufficient funds, late fee, and all that. But what I do have a problem with is these domino effects of their fees, that you're paying more and more money and nothing gets done. I shouldn't have to beg that office for 15 months to repair a driveway that violates state, federal, and housing guidelines. And it's a safety issue for me and every care staff that comes in here. I have 3 shifts of care staff and 2 nurses coming in here on a daily basis. And I shouldn't have to be put through the frustration and aggravation and worry that somebody is going to trip and get hurt coming onto this property site.
All right, let me ask you a question. How many times have you notified them of the issue?
Dozens.
And what
At least once every month.
By what method?
I was coming up there in person.
When is the last time you went up in person, sir?
I was in a bad traffic crash in December of last year. And I was in the hospital for 6 weeks.
Okay, so when is the last time you went up there, sir?
I would say November. Either November or December.
You know who you spoke to when you went up there last?
There's a bunch of different people. There was one young African American girl there. I forget her name. And she used to be in the desk as you're facing into the office. Several conversations with Brittany. Nothing got done.
Brittany's been gone for a while,
Yes, I'm aware of that.
at least since, I think, Ms. Green testified she came in July, I think, as a temporary.
Then there was a girl there. She was real thin, petite. Her husband drove a white Ford pickup truck. Because I remember talking to him. And she pleaded with me that she was new and that everybody's been yelling at her all day over the problems. And so I told her, don't worry, even though we have issues, talking, softly. I'm not trying to yell or scream at you. And I felt really bad for her because everybody else that day obviously was.
Thank you. Ms. Dornbush, any questions based on my questions?
Mr. White, did you submit any written letters to the community management office detailing your concerns?
No, I came there in person, addressed them in person.
And you've indicated in your testimony the bulk of your complaints went to Brittany Parker.
I say probably half of them. I have a crushed right hand. I only have 2 working fingers. It's hard enough just signing it and making out a check. I would never make out a letter, not even if I was writing it to my own mother.
I don't have any further questions for Mr. White, Your Honor. I do, though, have a couple questions for Ms. Green for rebuttal purposes.
All right, thank you. All right, Mr. White, thank you for your testimony.
Thank you, Your Honor.
I'm going to call your rebuttal witness at this time, Ms. Dornbush.
Thank you. Your Honor, plaintiff recalls Ms. Dana Green for rebuttal purposes.
Ms. Green, you're still on the oath. You may proceed, Ms. Dornbush.
Thank you, Your Honor. Ms. Green, in your capacity as community manager, do you experience residents parking on lawns or their guests parking on lawns often?
We do. It's something we work on weekly as violations go out, yes.
And do you know if have you witnessed vehicles parked on Mr. White's lawn on more than one occasion? Oh, you're muted, Dana.
Sorry. Other than the one that you showed on violation, no.
And do vehicles parking on lawns, is it known to cause damage to property?
Yes, it damages the property fully, so we do write them a violation to move it, or it will be towed within 24 hours.
Thank you. At any time during your employment as management, whether temporary or as the permanent manager for the community, were you notified of any concerns that Mr. White had regarding the dirt or grass area on either side of the driveway?
No, I was not.
With respect to the reason for maintenance's visit on March 18th, how did your team know to go there?
It was actually set up with you and Mr. White, a date and time that worked best for him. And then it was relayed to us to meet him or his care staff there at that date and time.
Thank you. Are you charging Mr. White to repair the driveway?
No, we are not.
Let me clarify that. Are you charging Mr. White to replace the driveway? Because you're not repairing it, you're going to replace the driveway, correct?
Correct. We are going to replace it, and no, we are not charging Mr. White for the replacement.
Thank you. And when you came on as temporary manager, were you replacing Brittany Parker as manager?
No, I was not.
Who were you replacing as manager?
Her name was Katrina. Do you want me to state her last name?
That I don't think that's necessary, but Katrina is not Brittany, correct?
Correct.
And do you know how long Katrina was manager at the property prior to your arrival?
I believe about 1.5 years. I'm not sure exactly on her time frame here as manager, but I believe around 1.5 years. Could have been a little longer or a little less. I'm not sure.
And let's just say we take a year into account. We'll just round it off there. And frankly, I don't know either, Your Honor. I'm just guesstimating here. But Ms. Green, if you came on in July and you are guesstimating that Katrina was there for approximately a year or possibly longer, that would calculate back to mid-year-ish of 2024, correct?
Correct.
Which is before Mr. White's stated time frame for when the driveway was originally poured, which I believe he testified was in November of 24.
Correct.
No further questions, Your Honor.
Do you have questions, Mr. White?
Yes, Your Honor. Ms. Green, are you there in the office nonstop from the time you arrive in the morning to the time you go home at night?
Yes, unless I have to step out to mail a package or go to the bank. I'm normally here from the time I get here to the time I leave every day, yes.
So if I told you I've been up there a couple times and you were not there, how would you account for that?
Like I stated, if I'm not in the office, then I'm either off of work or I'm going to the bank or the post office for work. But normally my work day consists of being here the entire time that I'm working.
Okay, and during them times that you step out to do other things, is the office locked up or is there somebody there usually to handle things in your absence?
The office coordinators would be here to handle things in my absence.
Yes, and sadly, 90% of the time, not necessarily you are better than the staff that you replaced. But 90% of the time I came up there in the last year and a half, the office manager was never in. I would rely on their employees.
Mr. White. Mr. White, you can't
Yes.
testify right now.
All right. If one of your staff that was there in your absence was to forget to tell you that somebody like me came up with this issue, how would you find out about it at a later date?
If I'm understanding the question correctly, you're asking if a staff member of mine forgets to relay a message to me, how do I find out? Is that
Yes.
correct? I would have to be told again, or the person or message would have to be relayed to me or staff so that I would hear it.
Would that require another phone call or another visit in person to do so?
You can raise concerns or put in work orders by coming into the office or making a phone call.
Okay. And prior to the pictures that were taken, is it your testimony that nobody in your office came by and looked at my driveway prior to your maintenance?
Correct.
Okay. Are you aware of the city, state, and federal housing guidelines?
I know.
Your Honor, I'm gonna object on which city, state, federal guidelines is
As it
Mr. White
pertains,
referring to?
as it pertains to concrete trip hazards.
He's asking which federal. Go, you're asking which federal state? I'm sorry, Ms. Dornbush, what's your?
Apologies, Your Honor. I was objecting because he just said, are you aware of state, federal, local, state, and federal guidelines? But I mean, there are numerous, and I was asking him to clarify with specificity which ones, and he did. He said regarding trip hazards.
All right, thank you.
Without looking them up specifically pertaining to something, as far as concrete, no, but you did share with us earlier today.
Okay, and that's all I have at this time, Your Honor.
Thank you. Ms. Green, I have some questions. How do you all document when someone comes in to file a complaint?
If it's a complaint or a work order will be put into our system called NetSuite. As well as if there's a complaint, they can go to the communication tab in NetSuite and write it down. Or if I'm present, they would pull me aside and have me come, handle it if I'm able to at that time. Otherwise, they would leave a note or email to me.
So they could put it in next week, or they can leave a note or an email for you.
Correct.
How, if someone left a note or an email, how is that memorialized? Is it transferred, or do you keep the notes? How does that work?
If it's a note, I would, definitely put it in the residence folder on the communication side. So we'd have relevant, documentation of it. And if it's an email, I could print it as well.
Is there a hard copy folder for Mr. White?
I'm sorry, what's that, Your Honor?
Yeah.
There's a hard copy folder that they have for you.
We do have hard copy folders for residents, yes.
Have you reviewed that folder?
I have.
And are there any complaints that Mr. White has made in that folder?
No, there's not.
So he hasn't made a single complaint since he's been there?
I wouldn't know if he has or hasn't made one since he's been here, but as far as there being a record of it in his file, in his hard file, no.
And are there any communications in the, what did you call it? Suite note? What did you call that?
It's our operating system. It's called NetSuite. Sorry.
Suite. Are there any complaints in that next week system?
No, there is not.
Any questions based on my questions? Ms. Dornbush is your witness.
No, Your Honor, actually, I had similar questions and you covered them, so thank you.
Mr. White, any questions from you?
Yes, Your Honor. When you said you changed from one system to the current one, is there any possibility that something could have been omitted, changing systems?
Your Honor, am I supposed to answer that or?
Yes, he's talking to you in the screen.
When the conversion from Yardi went to NetSuite, all data was transferred over.
That's all I have, Your Honor.
And Your Honor, just one quick redirect just on that point. Ms. Green, just to confirm your testimony earlier today was that the conversion happened in 2020, correct?
Correct.
Thank you. Nothing further, Your Honor.
All right, thank you. I'm thinking, give me one moment.
I'm on a Zoom court meeting right now, so.
So, you acknowledge, Ms. White, that, Ms. Green, that your system relies on individuals to input the data into either email or note or into the next week's system in order for it to be documented, correct?
Correct. With the NetSuite system as well, if the resident utilizes the resident portal, they can also put in their own work orders.
That's all the questions I have.
Your Honor, may I do one redirect question on that point specifically?
You may.
Ms. Green, in your experience as the manager at Lakeview and given the office coordinators that have been there during your tenure, do you have reason to believe that there is a lack of consistency by your team to note complaints and maintenance requests taken verbally into Yardi?
No, we would put them into NetSuite, but
I'm so sorry, thank you for clarifying, but the question stands.
Yes, we would put them into NetSuite, and no, since being the manager here, we've gotten on a consistent basis, and policies and regulations are held to a standard that they know to put them in immediately.
And you have not, have you seen there being a concerning amount of inconsistency, or would you say the staff has been consistent in your tenure there?
With me, under me, consistent, yes.
Thank you. That's all from me, Your Honor.
Anything else, Mr. White?
Yes, Your Honor. Does anybody in your office ever make a mistake? Ms. Green?
People can make mistakes, yes, they're human.
So it is possible that somebody did forget to bring this up after I came in person to look at it. Is that possible?
Based off the timelines given of when you've come into the office, I was not the manager here during that time. So under me, these office staff have not forgotten.
Okay. That's all I have, Your Honor.
Nothing further from me, Your Honor.
The trial is now concluded and it's time for closing arguments. I've listened to all the testimony, so please keep it brief.
I will, absolutely, Your Honor. I would just indicate that based off the testimony and the evidence that have been provided, the bulk of Mr. White's defense is strictly based on his own testimony. There's been no physical evidence from him provided supporting his claim that this issue was raised and reported to management prior to the commencement of this case. It's been acknowledged by the parties that once management was aware of it, they went out there and they started looking at it, and they are now on track to get the driveway replaced. Testimony from my client, from plaintiff, shows, and the photographic evidence shows that the driveway is deteriorating, but there's no testimony or photographic evidence provided to show that the driveway itself has any severe deficiencies. And did you have an objection, Mr. White, or something to say?
No, my back just spasmed. I'm sorry.
It's quite all right. Your Honor, in that regard, the documentation provided does show there's a balance due and owing to the plaintiff, and there's been nothing presented by Mr. White that would warrant any sort of reduction in the balance owed. Based on all that, Your Honor, we would request entry of a judgment of possession requiring Mr. White to pay the full $2,995.30, which does include $175 in statutory court costs, and with the requirement that that balance be paid within that statutory 10-day time frame, which would require payment on or before April 20th.
Thank you. Mr. White,
Yes, Your Honor.
your closing statement, please.
Their pictures, their own evidence shows that the dirt was never filled in at the edge of the concrete, which creates a 3 5/8 inch drift hazard, which is a safety issue and a violation of city, state, and federal housing guidelines. I also provided witnesses that come here to take care of me on a daily basis that stated that they don't feel safe and they have stumbled on that trip edge. Then also with the surface deterioration in the crumbled gravel, it's a huge safety issue for me being handicapped that I could slip and fall at any given point of trying to navigate that driveway. They failed to fix it. I proved with witnesses that this issue has been going on for 15 months and counting. And they didn't submit one contractor's repair estimate in the entire 15 months before your court. So, as a result of that, I feel that I should not have to pay any rent, or at best case, partial rent. And I'm not trying to sit there and, get 15 months worth of free rent. But I think obviously they should have to pay punitive damages. And I feel that I should not have to pay, that amount at all. And if I do, maybe be partial. Keep in mind, I got cashier's check for the whole amount and a written check for the balance. It's never been about the money. It's about them not getting it fixed, not having a contractor out here in 15 months to take a look at it. And, I'd rather go to the dentist and have teeth pulled than have to go through this again. So I'm asking you to deem that me withholding the rent was justified, and whatever money settlement that you want to do, I trust and have confidence in you that you would make the right decision. That is all.
Thank you.
And very briefly, Your Honor, just to close, just a couple of statements. The photos don't show, Your Honor, that the dirt was never filled in. The photos show the condition of the dirt on either side of the driveway as of March 18th. Mr. White has not proved that this has been an ongoing issue for 15 months. He's not presented any supporting evidence to that, and I don't believe his witnesses have testified that it's been an issue for 15 months. They've testified that it's been a long-standing issue. That is all. Respectfully, Your Honor, I don't believe that Mr. White's entitled to any rent abatement, but there is no counterclaim here for punitive damages, Your Honor, so he's not entitled to those either. And that is all.
All right, the court acknowledges there's no counterclaim for punitive damages, so that's not, the punitive damages are extremely difficult to prove in the first place. So that's not something the court is considering at all. I am concerned about the fact that very concerned, and I voiced that concern when we were here in court back on March the 27th was the first time that you saw me, on March 27th. But he voiced this complaint, at least in court, as early as February 11th. The problem the court has with this case is Mr. White, he seems very knowledgeable about concrete. He's indicating that he came into the office and he made complaints. The office has been having various people serve as managers for a while now. But my concern is his memory says that he's been in there every month, but obviously Ms. Green, who's been there for at least the past almost 8 months, 9 months, has not seen him, and I find it hard to believe that every month that he came in to complain from, let's say, July to November, even giving him the benefit of the doubt that he hasn't been able to go in since the accident from July to November, would forget to make any notation in the files regarding that. However, he seems very credible about his concerns regarding the sidewalk. And one of my concerns, Ms. Dornbush, is that he's correct. There's testimony here today that it's been looked at, but I don't have any proof that it's getting fixed. I know that Ms. Green testified that she spoke to someone this morning, but they can't even give her a date when that's happening. So I have that outstanding concern. I need an answer to that question.
Your Honor, I mean, I can provide the court with proof that a quote was received. That came in after the April 6th deadline, which is why I did not introduce it into evidence today. But that can be provided to the court. I mean, Your Honor, the concern that I have, and the court says that they find Mr. White's testimony very credible, but they should likewise find my client's testimony credible. They've testified under oath that they're going to fix it, that they are going to replace the driveway. They just got the quote for my own notification to the court, Your Honor. I know this wasn't testified to, but I believe it just came in yesterday or the day before. And so that is newly received. And as my client testified to, they reached out to the contractor this morning to try to ascertain a date that it could be done so that way it could be provided to the court during testimony today. If the court wants follow-up verification that it's scheduled, once my client has it, I'm happy to provide that to the court. I have no reason to believe, Your Honor, that my client would ever dare to step foot into this court and provide testimony under oath that they're going to replace the driveway and then not follow through and do it. My client would never do that. But I am happy to provide that proof to the court that it is being done. I know that there may be some concerns about weather and temperature, but things are on an upswing. Weather is getting warmer. And so I have every reason to believe that that's something that can take place fairly quickly. But I know we're working with constraints on a contractor. And so I can't speak to when that contractor is going to do it, but I will, as soon as we have the date, notify the court that.
Your Honor, did they sign the contract for that contractor to do the work?
As I was saying before, my concern still remains the same, which is when that's going to happen. And I heard you say everything you said, Ms. Dornbush. It is still my concern about when that is going to happen. Your view of the way the sidewalk looks is not comport with my view of the way the sidewalk looks. I think for someone who's on crutches, it's a very serious concern, especially the side of the sidewalk. I saw the pictures of a person who parked in a spot on one occasion, and somehow, according to Ms. Green, that's the only time she knows about that happening. And he also testified that it's that there are blocks on the side, and so it's not really on the grass usually, but the witness who was here today testified it was her car, and it was on the grass that particular day. So someone is paying attention.
I agree, Your Honor. My client is paying attention. They have testified that they are having it replaced. They themselves can't do it. They are waiting for the contractor to give them the date. Ms. Green, have you gotten a response back from the contractor since we've been in court?
I did. I was trying, I didn't know when I could interject, but she did get back with me at 12:43, and she said that I am just waiting on the permits to be approved and we'll get you on the books. So she's already requested for permits to be able to pour.
Did you sign the contract?
Approval was given by myself and higher management. That's why they've already moved forward with trying to pull the permits to get it on the books.
Did you sign the contract?
Or she's not on the witness stand team anymore. All right, so the bottom line is I have several issues with this. One, Mr. White, is that your testimony is that you've gone in, but you haven't taken any of the steps through the portal or through any other mechanism to document that you've gone in. And the witness testimony here today about the fact that you told them that you've been complaining is hearsay. I can't even take that into consideration. So it's just your word versus their word. My concern is that, you have severe memory problems, first of all. But secondly, there's this issue of the fact that Ms. Green can't testify to what he told people before him. But she also can't be held accountable for things that you told people before her when she's never been told herself. And there's no documented evidence that she's been told. Those are the concerns that I have, and I'm still grappling with that. The other problem, sir, is if you're going to withhold rent for issues, complaints, things that haven't been fixed, you have to have the documentation show that you've complied with the laws. The law requires, one, that if you withhold rent, you have to put it into an escrow account. I don't show that you put it into an escrow account. I do know that you showed the magistrate when you were here on February 11th, who held the $2,000 money order up to the camera and showed her, and she wrote a notation about that.
That's made out to send homes a cashier's check. My banks don't do escrow accounts anymore.
But the problem is, you withheld rent, you have no documentation that you told them that you were withholding the rent because of the concrete. Is there a letter or a document of any sort? You haven't presented that to me, that you were withholding rent for that issue.
Your Honor, like I said, I dealt with numerous people in there, and they just keep passing the buck down below. And before I even did this, I even warned them that next month I'm going to withhold the rent until you guys fix this. But I have a cashier's check instead of an escrow account because my bank don't do escrow accounts. But it covers everything. Payment in full. All I wanted was for my driveway to be safe for all the medical staff coming in and out of here, which it hasn't been. And it's a huge concern to me.
So this is what I'm going to do, because I do have concerns about his driveway. And I'm not telling you that I don't find it credible that she's going to be repairing the driveway. What I'm telling you is I want it documented. I want to see proof that it's happening. And what I'm also saying is that I believe that he told somebody at some point. Now, whether he's gone into that office every single month, I don't accept that part is true. I do believe that he's been talking about this issue for a long time. With respect to any argument as to the fact that he signed a lease and the lease got lost in the office and therefore he didn't sign another lease and he shouldn't have to pay the late fees and all of that. Mr. White, you have a duty to mitigate your damages and you should have actually decided the lease so that you could stop these additional fees from accruing every particular month. So you should be mindful of that in the future.
Yes, ma'am.
As far as the driveway situation is concerned and whether or not he's entitled to any abatement, I believe that the rest, so he only pays, is that site rent only and the actual lot, the actual mobile home belongs to the county, correct?
He owns the mobile home, Your Honor. He pays lot rent and then water sewer usage.
All right, I think what I need to do is look at the ledger, so to make my decision about what I want to do in terms of if there is any abatement. What I do want to see happen is I'm gonna have everybody return one more time for my ruling on this, and hopefully by that time we have the driveway fixed or at least a date for when it will be fixed. And I can do it on the standard instead. Just a couple weeks. Just, well, I'm not back. Am I back on the 29th?
You are back on the 29th. You had told me, but hold on, keep in mind that we're going on from the 22nd. The magistrate will be over to the 29th as well. So the 28th might be the date.
Is the first one in May? That's the first one in May.
Oh, the first one in May. That would be May 6th then.
I'll put it on for May 6th.
May 6th?
Correct. And I'm gonna do this at 3:30 PM. That's a standard Wednesday afternoon. I'll issue my opinion at that time.
Understood, Your Honor. With respect to, I know Mr. White had indicated that he had his payment for April. Do you want him to make that payment or hold it? And then same question with respect to May.
He should make his payment for April and May.
Okay, and is the amount in April going to be over $800? Because that's why I wrote the check for.
Your Honor, I can add up these charges for Mr. White if it pleases the court. Rent is $750, the month-to-month fee is $41, water was $20.63, sewer was $10.09, and then there's the $55 late fee, and I don't know what I did, but I just messed that up. Hold on. 1009 plus 2663 plus 750 plus 41 plus 55. It's 876.72.
76, 72. April. They'll have the check today.
Thank you. I'll see you all on May the 6th at 3:30.
Thank you, Your Honor.
Your Honor. Bye-bye.